Welcome to Looking at Legal Stuff. Today we have 13 hearings in 2 different custody cases, all of them with the same father. In the first case, Mom is filing for divorce after a DV incident that led to a restraining order and supervised visitation for Dad and their 3 children. In the second case, his ex-wife files for a restraining order and a change of custody for their 14-year-old daughter, who was present during that DV incident with her father and stepmother. Mom's lawyer claims she doesn't want to see her dad right now because she was traumatized and scared by what happened. Dad asks if the same GAL and mental health evaluation could be used in both cases, and the court allows them to do that. But despite agreeing to the mental health evaluation in the first hearing, he drags his feet over getting it done and comes up with a million excuses why the GAL hasn't been given access yet. He says he's worried about giving the GAL full access to his records because he has trauma in his past that's none of her business, and he claims he's just concerned his private medical data will show up on social media. What does the judge think of his claims? Let's find out. This video is a bit different than our usual ones. The father in this video was involved in 2 different family law cases during the same time period. We're going to watch the hearings in real time and jump from case to case as their hearings happened, as they share the same GAL. Don't worry, I'll make sure you know which mom is involved in each hearing as we go, so you can follow along and keep track of what's happening in each case.
I'm gonna call Bondurant and Bondurant 23-300-34108. This is on for temporary orders. I do have proposed orders here. I do see confirmation of service. Does appear, do we have Levi Bondurant present?
Yes, Your Honor, I'm here.
Can you take your hat off? Thank you. All right, so service was done. It appears I have a confirmation of service that was done on the 10th of August. We're now at the 7th of September. There was no response filed. So Mr. Bondurant, what's going on?
Right now I'm looking to get an attorney, Your Honor. But things have been a little bit rough for me in the last month or so. So I've been just trying to piece things back together.
Ms. Bondurant, is there I noticed that you referred to a restraining order. Is there a current one, or was that an old one that's lapsed, or is
it's a current one.
so there's still one in place at this point?
Yes, Your Honor.
And is that just for you, or does it include the children at all in that order?
It includes the children as well.
And when does that expire, or would it be set to expire?
So she ordered it to expire on August 21st of next year for me. And then he was told he could have supervised visits with the children, and he declined. And she said that he could do the video phone calls 30 minutes a day on that Family Wizard app, but I don't have the funds to pay for it. So he hasn't been in contact with the kids. And she said that that would be voided out per whatever happens in court with you.
Okay. All right. Well, here's where we're at. So, Mr. Bondurant, you have every right to get an attorney, but you were served and had plenty of time to respond to the petition with no response. I'm going to enter these temporary orders. So I do want to remind you that they are temporary orders. That means that they're not final. That means that they can be changed and can be revisited.
Your Honor, sorry, I apologize. Can we at least ask that a phone call or some line of communication can be had here. Because I mean, this is my kids have gone over a month, and in 9 years, they've never spent more than a day away from their father, and we're going on over a month, and there's literally no grounds for zero communication with my children.
Can I ask why you turned down supervised visitation?
I'll give you a couple reasons. Number one, the biggest thing is there's a lot of gray area. There's been a lot of there was like a criminal issue there that spiked up. A lot of things going on Facebook. It literally looks like Mrs. Bondurant is after to try to get me into trouble. And right off the beginning, I wanted things to kind of balance themselves out a little bit, because I wanted to see she first mentioned there being it wasn't the family wizard that she mentioned. It was there being supervised visits or communication over the phone. But I didn't want there to be like her jumping on the phone and then getting me into trouble, or like I was trying to source out the problem, what was going on there. Like if both of our priorities are for our kids, I know for a fact that my children would not be okay with going over a month without speaking to their father. I don't think that Mrs. Bondurant nor I have the funds at this moment to pay for the in court. I don't see where the harm is, as long as it's okay with Mrs. Bondurant to allow me to speak to the children. And she's not going to agree with where I have to reside. My kids would not. I'm still picking up all my stuff. She has the house, she has the car, she has the kids. I'm not going to put my kids in an unsafe environment. So I wouldn't want the visitation right now, but I would like to be able to speak to my children. And I don't understand why that's an issue.
Because she has a restraining order against you, Mr. Bondurant, and she would be the go-between. I'm assuming 8-year-olds don't have their own cell phones. Am I wrong?
They
do.
did have their own phones, but he didn't pay their cell phone bill, so they do not have a cell phone right now.
All right, so here's what I'm going to do. I'm going to allow phone contact through our family wizard. You can do phone contact through our family wizard free. So It can be set up that way. It also allows you to put any like important dates or anything in there, so he can still be in the loop on certain things. I'm also going to authorize, if you still are wanting it, professionally supervised contact. And that would be.
Well, I know.
Your Honor, I would be okay with my mom doing the supervised visits, but Mr. Bondurant also has to be aware that all 3 kids are on sports, and we are at sports every day but Friday.
Are you okay, Mr. Bondurant, with her mother being the supervisor?
Yeah, absolutely. I'd have no problem with her being the go-between. She also is speaking as if I don't know that my kids have been in sports for the last 10 years.
Okay,
so
this is not the place to be like petty back and forth with each other. I'm not going to have that. That's not what we do. Okay.
Yes,
you didn't respond, Mr. Bondurant. You're lucky that I'm giving you anything, because you didn't respond. You chose to do nothing for a month. And I understand you may have other things going on, but I would assume that your children are pretty important, and just responding would have been to your benefit. So I'll allow the non-professional supervisor. Miss Bondurant, what is your mother's name?
Sherry Reed.
Is that SHERRY?
Y.
Okay.
SHERRY and then REID.
REIDE. Mr. Bondurant, you know how to get in touch with Miss Reed? Mr. Bondurant, looks like he froze.
Yeah, he does. He is in contact with my mom quite a bit, actually. How long are these visits approved for? That way I can schedule it out in between, like with games and everything, and dates with my mom.
Your Honor, I'd be completely okay with whenever Sherry's available, whenever the kids are available, whatever works for the family as a whole. Like, even if it winds up being once every week or 2 in the temporary, I just want to be able to see or talk to my kids. That's the biggest piece here.
Well, phone contact can happen through our family wizard. You both need to download that app.
I have it, Your Honor.
And utilize that. And then there's a way that you connect with each other on that app, and then that allows the contact to take place. And if you schedule times through that app to make those phone calls, then she can ensure the kids are the ones that have the phone for those contacts. So here's what I'm going to do. I'm going to allow 2 hours per visit, up to 2 visits per week, depending on schedule. So clearly, I think 3 kids I saw, so, and lots of calendars. So hopefully you can work together to allow that to happen at minimum once a week, but up to 2 times a week. There was a request for an evaluation and treatment. I'm going to reserve on that at this point. I do think it would probably be a good idea to have a guardian ad litem appointed in this case. And I don't have an order for that. They are standard forms, but I am going to appoint a guardian ad litem. So the clerk's going to give us 3 names of guardian ad litems. You each have an opportunity to say, I accept any of those, or you can remove one of those people from the list. Does that make sense?
Yes, Your Honor.
Okay, so Madam Clerk, who are our next 3 GALs?
Amy Turnbull, Ann Height, Twyla Corey.
Thank you.
I'm
And
okay with anyone.
I'm sorry.
Any of them, Your Honor.
I said I'm okay with any of them.
And you as well, Mr. Bonneret?
Yes, Your Honor.
Okay, so we'll take number 1 on the list, Amy Turnbull. And I will appoint her as a guardian ad litem. What she's going to do once we get this order. And so, Ms. Bondurant, since you were able to get these orders in, there's another order appointing a guardian ad litem. If you can get that sent in, and we'll get it signed and filled out. Ms. Turnbull will send packets of information to each one of you. Make sure she has your contact information, your address. Fill those packets out, return them to her, and then she'll do interviews with you and other folks in your lives. And we'll probably speak independently with the children, and we'll put a report together and some recommendations of how to work through this process.
Your
All right.
Honor, I have a question.
Sure.
Do I have to serve Mr. Bondurant the motion that you want me to do for the guardian ad litem?
Yes, but because I'm ordering it, I would just give him a copy. I don't need formal service the way that you would have to do that normally.
Okay, I was just asking because I don't have his address to be able to serve him anymore because he moved from the last known address that I had.
Okay. Mr. Bonneret, you're muted now because that noise was disturbing the record. So you have to unmute yourself again. Okay.
I have no idea what that noise is coming from, Your Honor. I apologize.
That's okay.
She give it to her. She give it to her mother, though, correct? And then just pass it along to me because I'd be seeing the kids anyways at some point. Would that not work?
That's fine. Does that work with you, Ms. Bondurant?
Yeah, well, I was talking about for Ethan, like other paperwork that's going to be filed and turned in.
My hope would be that he would get his updated information to the GAL. And then, Mr. Bondurant, do you have an email address that you're willing to accept service in so you can get information from?
Yeah, that would be my first and last name at Hotmail. Mrs. Bondurant has that.
Okay, and you're willing to accept service on your email?
Specifically this or everything?
At this point, I'm asking for the GAL order.
Yes, ma'am. Yes.
And if you're not willing to accept anything else via email, that's fine. You don't have to agree to that at this point.
Okay. Like I said, I would like to speak to an attorney, so I don't know if that's a good thing or a bad thing.
So I'll just say that for this GAL order, you can serve him that via email. And then, Mr. Bondurant, in order to ensure that you get served, you'll just need to make sure that your name and address is updated with the clerk's office. So she has the ability to get information to you and serve you. Okay.
Yes, ma'am.
All right. I'm going to enter these orders. Assuming you can get that GAL order in within the next week, then that can get that process started. And I'm going to set a review out I'm going to set it to October 25th, 2023. Okay. There's going to be and that'll be at 9:00 a.m. Ms. Bondurant, on that GAL order, there's going to be a section where there's a GAL initial review date. That's going to be that October 25th. That's going to be when the GAL comes back and says, that, and hold on one second. And I'm going to reserve on fees at this time because I don't think I have, well, actually Miss Bondurant's portion will be county paid, and Mr. Bondurant's portion will be reserved at this point because I don't have any financial information. That'll be that review date. We'll see how things are going. We'll make sure that you both been in contact with the GAL, return the information that they've requested, and that the process is moving along. All right.
Your Honor.
Yes.
Your Honor,
Yes.
I also would not be opposed to Mr. Bondurant being able to go to the kids' game as long as there's no contact with them, if that makes sense. Like, he can watch their games, but as long as there's no contact with them before or after the game, because I know their sports is a big part.
Your Honor, that goes back to being that gray area that I'd be concerned about. I'd love to go to my kids' games, but being that Mrs. Bondurant would be there, that could theoretically put me in violation. I wouldn't feel comfortable with that at this time.
I can understand that. And so that is that is a gray area, because if for some reason a law enforcement officer sees the protection order and you're both at a game, even if you're some distance apart, if he's not, at least usually it's 1,000 feet apart from you, then that could be a violation and he could get arrested for that. Well, and I understand, I think that's a good intention, but I don't, I understand Mr. Bondurant's concern there. In that Our Family Wizard app, there is the free part of Our Family Wizard does have a calendar app that allows you to kind of upload your kids' schedules and stuff. And maybe if there's a game you can't get to or something, you can note that on the calendar, and maybe he can attend a game that you're not at.
Also, there's a lot of ways to virtually, a lot of those games are virtual as well. So, I mean, you could probably post those videos or those links on the app, correct? As well.
Yeah, you can message on that app. So, okay. All right. We'll see you back on October 25th, excuse me. Good luck to you both.
Okay, and then I have the Bondurant case with Ms. Turnbull that it sounds like we can talk about how we're proceeding. This is 23-300-34108. Good morning, Ms. Turnbull.
Good morning.
And then I see Mr. Bondurant and I see Chelsea Bondurant. Okay, let me just get into the digital file here. Okay, I had us on today essentially for a review hearing. I know we just assigned a guardian ad litem last month, and it sounds like Mr. Bondurant might be an issue with you returning paperwork and that sort of thing. So Mr. Bondurant, let me know it sounds like you might have a request of the court.
Yeah, Your Honor, I was a little bit late to get that documented out. There's a few items in there that I didn't have information on, and but it was completely on me as to why that document ended up being turned in late. It is sent by priority mail to be received by Amy, I do believe today. So, and then I also didn't realize that I would qualify for the financial declaration aspect of it to help cover the costs. So that also is being turned in today as well.
Okay. Okay. Ms. Bondurant, it sounds like we're just going to need a little more time to do, the GAL can do more investigation and give recommendations to the court. Do you have any position today?
No, Your Honor.
Okay. Ms. Turnbull?
Your Honor, I have had a chance to interview Ms. Bondurant, and I do think there's enough information that I would like to request that Mr. Bondurant do a mental health evaluation.
Okay. And because I don't have anything in front of me, can you give me a brief basis for that request?
Yeah, he has a history of, let's see, let me look at my notes here, borderline personality disorder and bipolar disorder, and has historically been on medication, and about a year ago, he stopped taking his medication. And according to Ms. Bondurant, this is when things in their relationship deteriorated, and when the problem started, and has not been taking his medication for about.
Okay. And it looks like I'm just looking at the temporary order that the judge signed. Is there any visitation currently happening with Mr. Bondurant?
He's doing 2-hour supervised visits.
And is that still happening with your chosen non-professional supervisor? Is that person working out?
Yes.
Yes, Your Honor.
Okay. So Ms. Bondurant, are you requesting that he undergo a mental health evaluation?
Yes.
Okay. Mr. Bondurant, do you have a position on that? Is that something you're willing to do to move forward with review of visitation?
I mean, I got a couple issues here. I mean, it's hearsay as to make a diagnosis of any mental health issues. So I want to state on the record that that's inaccurate diagnosis of that. But I would gladly take a mental health evaluation to alleviate the court's worry on risk.
Okay. So, and I'll just state, in these types of family law hearings, the rules of evidence are relaxed, meaning things that in a civil trial would be considered hearsay. We don't have that type of exclusion here. We use GALs to do that kind of fact finding and report back to the court. So I understand your statement to the court, but I will overrule that objection. I will allow Ms. Turnbull's statement into the record. It's not there to prove the truth that you have a mental health condition, but simply as a basis for the court thinking, yeah, this is probably a good idea as we determine what's. Mr. Gilbert, can you please mute? As we determine what's in the best interest of the children. So if you're willing to do that, I do think that makes a lot of sense to move forward with determining what visitation looks like in the future. I'll do a bench order today. Ms. Turnbull, any other specifics that you would want to see in the bench order for the mental health eval?
Well, I know that I would imagine cost is going to be an issue, so I would like to see a PhD level, but I think that if we could even just get a master's level at this point to do an initial evaluation, that would be helpful. And have collateral information from Ms. Bondurant, that would be appreciated.
Okay.
Your Honor, you'd have to, I don't understand the terminology when she says collateral. Can you help me understand what she's saying by that? Or Amy, could you by chance tell me what you mean by that?
Let me ask you this. Do you have a mental health provider you currently see?
I'm in counseling, Your Honor, but as far as a psychologist, no.
Okay.
There was what was that?
Do you have health insurance that could help cover the cost of an evaluation?
No, I don't.
Okay. Ms. Turnbull, do you have any recommendations where he could go for an evaluation like that at a lower cost?
I can look into it for you.
Okay.
I mean, my request, Your Honor, would be I guess where I'm getting a little confused as to why requests are being made specifically from the guardian ad litem on a one-way evaluation. At the time, putting this over to allow both sides of the case would seem to make more sense. But I mean, if this could expedite the situation a little bit quicker, then, like I said, I don't know what the timeline would be for that because cost would be an issue.
Yep. So what I'm going to say is I'll respond to your question, and I understand proceeding through some of these family law matters is confusing. So there's a temporary order in place that a judicial officer in this county already signed. And in that temporary order, they did find you specifically, not Ms. Bondurant, but you specifically have what we call our 3A and 3B factors that may limit your ability to see the children, that in fact do limit your ability to have full visitation unsupervised. Because of that, we probably are going to put more requirements on you as we go through visitation than we would Ms. Bondurant. That does not mean though, sir, once you have your intake with Ms. Turnbull and you can tell her your concerns about the parenting plan, it doesn't mean that there won't be further requests made. It just means today, based on all the evidence I have in front of me, this first step seems very appropriate for the best interest of the children. And it doesn't,
Absolutely.
yeah, it doesn't mean we won't be doing more or less in the future. It just means right now, this makes a lot of sense.
Okay,
Okay.
absolutely.
So what
Yes, ma'am.
I'll do is I will sign a bench order for the mental health eval, and then to comply with any recommended follow-up treatment. But Mr. Bondurant, if you want to reach out to Ms. Turnbull, she can, she's going to do some research into some lower cost evaluations that you might benefit from, okay?
Okay, perfect.
And then do we already have another review date set?
I don't think so.
We don't. So how far out, Ms. Turnbull, would you say? Another 30 days?
I think that would be helpful. And yeah, assuming that Mr. Bondurant has, received his paperwork in the near
Okay.
future here.
Your Honor, can I ask you actually one other question that I don't know if it would be relevant or not? There's actually two cases, two different cases in this with my three youngest and my one older. And I know that a requirement in that case also is a mental health evaluation. Is this something that I'm going to have to do twice, or is this something that can be utilized in both cases?
Which other case, what type of case are you referring to?
It's also a family law matter, very similar to this. They're running pretty much bilaterally.
Oh, but different mother?
Yes, ma'am. Yes, Your Honor.
Okay, I did see your name on that. If I can pull the case number for that, I have no problem with those obligations being concurrent, meaning the mental health evaluation for one can be filed under both.
That would be fantastic.
Okay, let me see. Do you have his other? The clerk's going to help me out with that case number and I can put that into the bench order. So when it's done, it'll qualify for both.
Awesome. Thank you.
So while she's doing that, let me give you your next hearing date. I'm going to propose Wednesday, November 29th at 9 a.m.
That works for me.
Okay, Ms. Bondurant,
Your Honor?
does that work for you?
Yeah,
Okay, do you have anything else you need from the court on this matter?
no, Your Honor.
Okay, Mr. Bondurant, does that date work for you?
Yes, Your Honor.
Okay.
Mhm.
Yeah, we're still pulling up your case number. Just hold tight with us for a minute.
Okay. Also, actually, while we're on that, from that case number, I know that Ms. Turnbull may have an issue with substance abuse at some point in her report. I actually also submitted to a hair follicle and UA that I had to pay out of pocket for. I do believe actually you actually required me to submit to that in that particular case. So can that be utilized also?
Yes, if you want to get those results to Ms. Turnbull, I highly recommend it.
Okay, perfect.
Okay, hold on. I'm going to get that case number. Yeah, yes.
13-300-206.
Let me read that back. 13-3, excuse me, -00206-4. Okay, I'll get that number put into the bench order that I do. If there's nothing else, the parties are free to log off on this matter.
Thanks. Next, I have Levi Bondurant and Tristan Peterson, cause number 13-3206-4. Ms. McLean is present. She represents Tristan Peterson. And I see Ms. Peterson is on the line with us also. And then is Levi Bondurant here today? Mr. Bondurant, I see that you're on the call and just want to make sure that you can hear me. Mr. Bondurant? Mr. Bondurant, if you are speaking, I see that you're muted. So make sure you're press the button so you can unmute.
Yes, Your Honor, I'm here. I apologize. I was having trouble with Zoom.
Okay, all right. So Mr. Bondurant is present. All parties are here. This is on a motion brought by Ms. Peterson. And let me just pull up my notes in a moment. Okay, so this is an issue related to an adequate cause to modify the parenting plan. And one quick question before we get started, question for Ms. McLean. Looks like service upon Mr. Bondurant was effectuated for today's hearing on October 12th. And
That's correct.
how does that square with the 20-day rule?
Technically, it doesn't. So Mr. Bondurant had not requested, he's been in communication with me. He did not request a set over. So we're here today based on the notice that he was served.
Okay, all right. So, Mr. Bondurant, did you file anything in response to the issues that were raised by Ms. Peterson?
No, Your Honor, but I mean, the order that was served to me or the paperwork, it was extensive. I was actually hoping to potentially get a continuance anyways, contingent with the fact that I already have a mental health evaluation that I feel like this court could use in another case that Miss McLean is actually asking for also.
Okay,
And
no, go ahead and finish what you were going to say.
I actually have another child custody case that's running parallel to this, and I did submit to a mental health evaluation in that court hearing. It's something that Ms. McLean is asking for, and I feel like it could be super beneficial to me moving forward. And as far as the amount of time, I'm not an attorney, so I don't know what my allotted times are for going through this paperwork or filing the paperwork in response to hers. So I was hoping to get a continuance anyways based off that information.
Okay. Ms. McLean, any comments?
My only comments would be that certainly this is not Mr. Bondurant's first time being in court. If you go back and look at the history of this case, there have been several different court hearings involving this matter. Also, if you take a look at the summons as well as the order to show cause that were served upon him, there is identification of what he needs to do as far as following up and making sure that items are filed with the court and provided to me. So if the court is inclined to set this matter over, I guess the question is when is he going to provide his documentation? My other comment would be that obviously my concern is that any mental health evaluation that he's completing pursuant to my client's motion, we would ask that that include collateral input from her, given the substantive or substantial information that she has as to his mental health history. And then I would want an opportunity to obviously put together reply documentation for the court.
Your Honor, can I speak?
Mr. Bondurant, just following up on that, as far as your time frame, what's your time frame? When do you plan to file responsive documents to the issues that Ms. Peterson raised in her pleadings?
Well, the the only real issue that I'm like
I kind of
2
need
weeks.
2 weeks, you say?
Yes, Your Honor.
So you would file that information in 2 weeks from today. Ms. McLean would have it, and then she and her client would have opportunity to review it, and they'd have opportunity to reply or send in documentations to the court to what their position is to what you said. And then that usually means that we would set a hearing basically 2 weeks after that, basically, so we could hear what everybody has to say on that. So it'd be roughly 4 weeks.
Okay, Your Honor. I mean, I don't know if that's okay with you guys, then that works for me. Like I also said, and I know she mentioned that she in her order that she did ask for that there be input from Mrs. Peterson. However, there has been a very broken line of communication for over 10 years. She has absolutely zero knowledge as to my mental health. I don't feel that that's relevant in any terms at all.
Okay, thanks. The mental health piece is just like medical information. My experience has been that when evaluators are looking at that, having a long history, although it may be somewhat dated, provides a better, clearer picture for the evaluator. A person may not have up-to-date information about a person. However, if they have historical information, the evaluator can take that into consideration, give it what weight it's due. So I think that is an important consideration. So I would require that if you are going to get a mental health evaluation, which I think is that's great that you're being proactive like that, that Ms. Peterson would have opportunity to provide collateral input.
Your Honor,
I would
sorry, I
require
apologize.
that. Go ahead.
My issue there being is that the person who would have the most knowledge or input and I know Mrs. Peterson and my wife are in conversations. The same input would be provided to the evaluator based off of my wife's information, which is being inputted in another case. I think that if I put in several different inputs, it's going to create a very biased opinion. From the beginning, I'm already complying with the courts in terms of where and who and what their credentials are required. I feel like that in order for me to have a fair assessment, that the input of one and the most relevant spouses or ex romantic, whatever you want to call it, it would be necessary.
Yeah, I think I hear what you're saying is that you're concerned if that there's maybe collusion between Ms. Peterson and your wife related to any evaluation. Evaluators are pretty savvy folks, has been my experience. We trust them to take information, weigh it, check sources and motivations why they may be sharing that information. And they may discount a lot of it because the motivations in their view, may be deemed, not credible, or they may have an axe to grind or what have you. But I think with this mental health evaluation, I think especially with medical issues, a longer view often gives evaluators more information, and more information generally leads to a more precise evaluation. So notwithstanding the objection, I will require that any mental health evaluation, Ms. Peterson would have opportunity to provide a collateral input to the evaluator. So we will come back in 4 weeks, and then Mr. Bondurant, you indicated that you would be having all your documents filed in 2 weeks. So that means by November, let's see, what date would that be? November 14th, you'd have all your documents filed with the court, and a copy provided to Ms. McLean on that same date, if not before. And then we would be back here on the 28th of November.
Your Honor, is Mrs. McLean requiring or asking for a guardian ad litem in this particular case? Because the paperwork that I did get, there's already a guardian ad litem in another court case, and can that be utilizable?
Ms. McLean is asking for a guardian ad litem to be appointed.
Can we utilize the same guardian ad litem as far as in terms of saving from a financial? So we have to do separate guardian ad litems?
These will be things that we'll talk about when we come back to court on November 28th. They're important issues, but yeah, we can talk about them on November 28th.
Okay,
Your Honor,
thank you.
I'm sorry. The only clarifying information that I need is that Mr. Bondurant is referring to an individual and credentials as far as this mental health provider. I don't know to whom he's referring or which court has ordered him to do that. I'm assuming maybe in the matter involving his wife, Chelsea, but I don't know who the individual is. So I would need to know that information.
Just who the evaluator is.
Yeah.
Yeah. Mr. Bondurant, can you, that would be important information in order for Ms. Peterson to give that collateral input to that evaluator. Do you have the name of that individual?
It is through Core Health. I actually can provide that information. I don't actually have a specific name. The day that it was asked of me if I would get a mental health evaluation. I felt that it was in the best interest of the child and myself to provide that for the courts. And the same day I did schedule an appointment. However, I don't know the name of the specific person who's going to be doing it. I know that it met the credential requirements,
Okay.
and it's on the 6th of November.
Okay. Do you think you could contact that individual today, find out their individual's name, and then notify Ms. McLean by close of business today?
Yes, would it be okay if I send you that information via email?
Absolutely. And I would just note that I've had other cases involved where Core Health has been requested to do mental health evaluations with collateral input, and they've declined to do that. So I'm just providing that information up front. We've actually had to seek other providers outside of Core Health.
Interesting. Okay.
I don't have any information in regards to that. So is that something that I have to contact Core Health and ask them if that's something that they're willing to do in this particular case? Or is there paperwork?
Yeah, I think that would be important. I mean, you as the client, you could certainly make your wishes known, like, hey, I'm the client here, and I would like to have Ms. Peterson provide collateral input. Not that that's what you're wanting, but that's what the court has ordered. So yeah, I think if you make that known to them, that would be really important. And please do that, and then let Ms. McLean know who that individual is.
Okay, and do I need to place in an ROI for Miss McLean as well?
It would be for Ms. Peterson.
Okay, so the ROI would be Mrs. Peterson then.
Right.
She would be providing the collateral input. And the prior provider that I'm aware of was Ms. Ludvigson, Ludvikson. She was unwilling to do that. Just so.
Okay.
This is what I do know is that this is a male evaluator.
Okay.
All right. Great.
Thank you.
Okay, great. So we'll see everybody on the 28th, and Mr. Bondurant, you'll have your pleadings filed and copies given to Ms. McLean by the 14th, and then by today, close of business, you'll provide that name to Ms. McLean.
Absolutely, Your Honor. Thank you.
Okay, great.
Thank you.
Thank you all.
And then let's see, I've got Ms. McLean, Mr. Bondurant. Looks like I've got everybody here on this one. Got some other folks. I'm not sure who is there here on. So I did have a chance to review this. This was also a little confusing. It looks like Judge Evans heard something on this on the 31st.
That's correct. At that time, Mr. Bondurant had requested a continuance so that he could provide reply documentation. That was granted. There were some other rulings that were made by Judge Evans at that time. And one of which was that Mr. Bondurant was to file responsive documentation by November 14th. And so we had filed our motion for default. He was served with that on November 7th. He has not filed a response to the petition. So we're asking that the court enter an order of default. It's been 47 days since he was served in this action. And the court, as indicated on October 31, advised him that he needed to file responsive pleadings by November 14. If you go back and look at the
well, I'm looking at the clerk's notes, and it doesn't talk. It talks about some. I mean, he filed the responsive documents on the 13th. It's not a formal answer, but he filed a responsive document, which is what that seems. So I'm going to defer on the default issue to Judge Evans. I can set that over. I don't know what he specifically ordered because it's not. I mean, it says to me.
Well, at this point, I've properly served him with a motion for default. He's had.
And I'm denying the motion based on the fact he filed a response. It's not in the proper form, but it's a response to the petition essentially. He needs to file an answer. I can give him a week to do that, a specific answer as opposed to the response that was filed on the 13th.
Will the court set that for sure that motion over to December 5th then?
I certainly can. So, Mr. Bondurant, I want you to understand what that means is there's a document called an answer that you need to file. which is different than what you did file. You filed the proposed parenting plan, you filed the declaration responding to all of these things that are in here. I don't know what Judge Evans specifically said because I don't have that in front of me, but it looks like he told you to file something on by the 14th, and you filed on the 13th. So you're going to have 1 week over to next Tuesday, the 5th of December, to have an answer filed. It's a form. You can get it off the court website, the state court website. All right.
Yes, Your Honor.
If not, you'll likely be found in default, which severely limits your ability to participate in the proceedings.
Okay, and Your Honor, I do have one small issue here. Is I start work on the 5th, and I have to have almost a month of uninterrupted work between 7 and 3 o'clock. So, I mean, on one hand, I'm being asked that I need to do this and I need to be able to do that, and then I'm having to go to all these court cases. I was unaware of this form. I don't recall Mr. Evans specifically providing that. I'm not an attorney, so unfortunately, I don't know the ins and the outs. I know that I met the deadline for what I thought that I needed to provide. I obviously don't want to drag this out. However, I do have a request that basically that I would need the month of December to push these things out. I already don't have visitation. I already don't have contact. So I don't see where the harm in pushing that out an extra month would be. That protection order doesn't end all the way until August.
Well, he doesn't need to appear on the 5th if he's complied.
Right. The issue really is you need to file the document. The form's available. And the reason I'm setting it over a week is, in fact, in part because you're self-represented. I want to giving you the opportunity to file the correct form. I'm not going to find a default based on you filing the wrong form. So you'll need to get that, download it, answer the petition, and get it filed. You don't have to be here next week if you don't want to, because unless we set some other things over. So, and I guess
I could file that, Your Honor.
All right, so you get that done. We could address the other matters that are before the court. One is an adequate cause request.
And I do have a preliminary request as well that was outlined in my client's reply declaration. Mr. Bondurant's responsive declaration, which is clerk's paper 50, I'm sorry, clerk's paper 81, has as exhibit 1 an excerpt from the sealed portion of the prior guardian ad litem report. I think it's improper to put any portion of the sealed guardian ad litem report into the public file. In addition, exhibit B is documentation from Washington State Support Registry that includes the party's confidential 4D number. And that would essentially be treated like a social security number and the like. That should not be filed in the public file. So I'm asking that clerk's paper 81 in its entirety be filed under seal, and that a redacted copy of clerk's paper 81 be refiled, redacting those 2 exhibits, which is consistent with the information that the clerk provided at our last family law brown bag hearing.
Your Honor, the exhibit that I did put with the guardian ad litem report has absolutely no I don't understand who it would hurt to not be under seal. It really only mentions myself and something very sensitive to me. So for that to need to be under seal, I don't believe. Also that that ID number is also something that I could obviously refile and black out the ID number. I was not aware of that. But I mean, it does seem kind of silly. There's not much information that can be gained from that ID number. Anybody can call up underneath my name or anybody's and get that ID number if they wanted to.
I think that that's an inaccurate statement. That is a confidential number specific to DCS.
I don't know if it is or not, frankly. Those get filed all the time. I don't know if they're confidential normally. But the other document, if that's from the confidential portion of the JL report, that should be filed under seal. So since we're going to be doing all of that, I'll order that all of that both of those be filed under seal.
That clerk's paper 81 be filed under seal, and then we'll file
Well,
a
just the
redacted.
exhibits.
They can't split it up. It has to be the whole document. That was the purpose of the training that we had on Thursday.
Okay, I apparently wasn't at that training. So well, I guess what you'll need to do then is file that under seal and then file the declaration referencing the exhibits that are under seal, because the
Correct.
declaration itself wouldn't be sealed.
So we'd have to file the whole clerk's paper 81 under seal. And then we would have to refile the 81 with A and B redacted from that into the public file. I'm assuming the clerk can maybe chime in.
Correct. We would likely just file it as like 81.1 or reference it later in the case.
Well, I'll order that we comply with whatever the clerk's rules are with regards to confidential sealing and how that gets accomplished. You'll need to work with the clerk's office to do that.
All right. So then that brings us to my client's request for an adequate cause finding and temporary orders.
Right. And the adequate cause, I'm not sure if you're objecting to that, sir. This is simply the threshold finding of the court to determine whether or not it can actually review the parenting plan and that sort of thing. Seems to me that's met, but I don't know if you have an argument against that. I didn't see one.
In terms of her proposed temporary plan for the child?
It's meeting the threshold for the court to be able to take a look at the parenting plan, to adjust the parenting plan, that sort of thing.
No, I don't disagree.
Okay, so I'm going to enter that order. That seemed appropriate, but I wanted to sign that order.
And I'm sorry, Your Honor, I do have a quick question. I know that Judge Evans required me to meet a deadline. I don't know if that was me needed to meet a deadline or both me and Tristan's attorney need to meet a deadline on the 14th. But in her response that went beyond the deadline on the 14th, she brought in different exhibits that were unrelated to my response at all. And I feel like that should have been a declaration that should have been presented prior to the deadline.
So I didn't have a deadline by the 14th. Our deadline would have been a week ago, which we met. My client's reply documentation was filed on November 16th. It was in response to the allegations that he was making relative to his the claims that he was not involved in counseling decisions for Ellie early on back in, I think it was 2020. The claims that he does not have the ability to provide the financial support, and in response to his allegations that he shouldn't be required to participate in the services that we are requesting and the findings that we're asking against him. So I think that is strictly in response to his information. It's also documentation that's in another court matter that Mr. Bondurant is involved in as far as his dissolution.
Okay, well, it seems to me this is a case where, and we may want to wait until we see if there's a default issue addressed. My thought would be just a case where we probably need a guardian ad litem appointed to look into the matter.
That was another area that I'm confused on, Your Honor, because there is a guardian ad litem have been in another case for my other 3 children that has been appointed. I do recall Ms. McLean
So is the court
requesting.
going to, can I ask for a point of order at this point? Is the
Sure.
court, are you going to hear the motion, or from what you just indicated, you question whether or not we should be proceeding as far as the concern relative
Well,
to the default?
there's a couple of things. I'm hearing the motion, but I guess my question is, do you want to wait until an issue's addressing the default is addressed?
I mean,
I think as far as the appointment of a guardian ad litem, yes, I think that we should
Okay.
wait on that.
Okay, so we'll set that over. As far as your request on temporary orders, that's, I think, what we have left. Am I not mistaken?
That's correct.
Okay.
So with that, this matter all started with a protection order that was entered on September 12th of 2023 that protects Ellie from Mr. Bondurant. Ellie is currently 14 years old, and she has been exposed to domestic violence by Mr. Bondurant within his household and directed towards Ellie. Uh, Obviously, 14 is an impressionable age, and Mr. Bondurant should be modeling the type of role model that he wants his daughter to experience on her own in the future. Instead, Mr. Bondurant has been engaging in domestic violence, substance abuse, primarily alcohol, untreated mental health, and overall instability as it relates to his housing, his employment, and the like. Findings from the contested protection order hearing found that Mr. Bondurant is a perpetrator of violence within his household, and that Ellie has experienced anxiety, apprehension, worry, and prepared a safety plan with her mental health provider relative to what she was experiencing during visits with Mr. Bondurant. During the most recent domestic violence incident, Ellie was directly involved, and Mr. Bondurant interfered with what he believed was Ellie's attempt to call the police as directed by her stepmother, Chelsea, when she, in fact, was too scared to call the police and had actually reached out to Ms. Peterson, her mother, by text. Ellie has disclosed to her counselor about struggling with her father's behavior, and this has been going on for years. Ellie has described her relationship with Mr. Bondurant as negative, poor, and non-existent. And Ellie's relationship appears to be tied more with her stepmother and her half-siblings, which actually is acknowledged by Mr. Bondurant. When Mr. Bondurant was removed from his residence with Chelsea earlier this year, I believe that was March or April of this year. At that time, he was not exercising visitation with Ellie. Ellie was actually going over and exercising visitation with Chelsea and her half siblings. So there's been protracted periods of time when Mr. Bondurant has not been exercising visitation. He did not exercise his summer visitation, and Ellie has continued to struggle. Mr. Bondurant claims in his reply declaration that he was not advised when Ellie was first engaged in counseling. Ms. Peterson provides to you as attached Exhibit A to her responsive declaration filed on November 16th, the text message communication between the two of them in October of 2020, where they specifically discussed counseling, and he was all for it. Now he attempts to suggest the sufficiency of the counseling is inappropriate because she's had intermittent periods where she hasn't been in counseling. Obviously, a counselor can't continue services if there's nothing that needs to be worked on, and mental health is a progress in motion. When the symptomology decreases, then typically counseling decreases. When the symptomology comes back around or increases, then counseling increases, and that's exactly what Ellie has experienced. There is nothing nefarious in providing Ellie with outside mental health support, particularly when she's experiencing the disturbance within her father's household. And to be quite honest, These kids have weathered a lot over the last couple of years. And for a parent to not take into consideration a child's mental health when they're reaching out to a parent for help would be not in the child's best interest. And if we were in that position today, I suspect that Mr. Bondurant would be making the other argument that somehow Ms. Peterson would have been neglectful had she not been meeting Ellie's needs. Parents need to take a child's mental health seriously, just as Mr. Bondurant needs to take his significant history and ongoing mental health issues seriously. So our position is that it is appropriate for Ellie to continue in counseling, and it's instructional, the fact that she has in fact had to enter into a safety plan for how to deal with her father. I think that that is information that is important for this court to be aware of. It's also concerning that following the entry of the protection order earlier this year, or I guess it'd be a couple months ago now, that at that time, Mr. Bondurant was ordered to participate in a hair follicle. He made a claim in court, he was on Zoom, that he was not in the local area, when in fact my client recognized his location and he was in the local area, and he put off participating in the hair follicle. So that makes us question the veracity as far as whether or not he had done something to alter that test result. The other concern is that most recently, Mr. Bondurant, again, our perception is that in violation of the protection order, has attempted to friend Ellie on TikTok when he's to have no contact with her. Ellie did not accept his friend request, but we did again provide that documentation attached to my client's reply declaration. Mr. Bondurant does not have stable housing. He has not had stable housing since his separation from his wife earlier this year. He is not in mental health counseling, despite an involuntary commitment for a suicide attempt in 2018. And while he claims he's got a job, and while his financial declaration that he filed in his divorce action suggests that he had a job up through April of 2023, there is no financial documentation that he submitted and no disclosure as to what his employment has been. Mr. Bondurant's active case with his wife, Chelsea, it is accurate that there is a guardian ad litem that's been appointed in that action. There's also been a temporary parenting plan entered in that action here in Cowlitz County Superior Court. We provided that at my client's exhibit, I believe it's Exhibit C to her reply declaration. That was filed on September 7th. That order makes specific 191 findings against Mr. Bondurant, including domestic violence, assault, and emotional or physical problems that interfere with his ability to parent. So those are already findings that this court has made, as well as coupled with the findings that were included in the protection order. Mr. Bondurant has acknowledged that he has emotional problems, and at our last hearing, he did agree to participate in a mental health evaluation. It's notable that that was actually ordered in his dissolution case by Commissioner Carmi. So the grand gesture of agreeing to participate in that was something that this court had already ordered in another case. Apparently there was a discussion because the order also indicates that that could be correlated with whatever is ordered here. So Judge Evans at our last hearing ordered Mr. Bondurant to disclose who the mental health provider was so that my client could provide collateral input. He did provide that information to my office. My client did talk to a Mr. Dillagrange at Core Health on November 8th. I don't know the qualifications of Mr. Dillagrange. As you can see from our proposed parenting plan, the request is, and this is at paragraph paragraph 4 B1, we're asking that Mr. Bondurant, given his long history of mental health instability, that he participate in a psychological evaluation with parental risk components. Mr. Bondurant, as indicated previously, had a suicide attempt. He has been involuntarily committed for a period of time as a result of that. He has continued to engage in substance abuse. So the concern is with reference to a dual diagnosis. And he's continued to engage in inappropriate domestically violent charged behavior in front of all of his children. So the reality is that we think that psychological evaluation with parental risk components will provide more information to the court rather than simply a mental health evaluation. So we're asking the court to order that. At this time, we have not received any follow-up information from Mr. Dillagrange. Mr. Bondurant has not provided that evaluation, and we've not seen any of that. I noted that when I was making my, I'm sorry?
I said I'm under the impression it's your responsibility to reach out to Core Health for that information. That's the idea of the release of information.
Okay, I don't believe that I've received a release of information. I'm not aware of that.
I sent you the information that there was a release of information provided to you. Actually, not to you, to Tristan, which is what at the court's request. And it was something that I volunteered for.
This is not an objection, Your Honor.
Hold on, sir. Let me just listen to what the argument is, and I'll hear from you.
Okay.
So I would note that during my argument, of course, he's raising his hand about the suggestion that he's in mental health counseling. That's my assumption as to why he was shaking his head and raising his hand. The issue is that we have no documentation or information that supports that he's involved in any type of services at this juncture. Currently, with the no contact protection order, we are also asking that the court enter a restraining order in this case, enter our proposed parenting plan that provides for no contact. His daughter has expressed being scared of him, being fearful of him. This is not a one-off. This has been going on, and it's outlined within the counseling records that have been provided for a protracted period of time. This is a gentleman who has issues that he needs to address. So we're asking that the court adopt our proposed parenting plan with the 191 factors that include the domestic violence, neglect, emotional or physical problems, substance abuse, and use of conflict. Outlined within my client's declaration were the issues relative to the substance abuse and how Mr. Bondurant often consumes alcohol the night of the incident, where I guess, Your Honor, I would just make a note that it appears that Mr. Bondurant is vaping during our hearing. I don't think.
I'm not watching, Mr. I'm listening to you, Counselor, but sir, you shouldn't be consuming anything while we're talking. Go ahead.
I apologize.
So in any event, my client outlined in her declaration the issues regarding the substance abuse, the incident with him demanding to drive intoxicated with Ellie and his oldest daughter, and Chelsea stepping in to prohibit that from occurring. His alcohol consumption and the domestic violence that occurred that directly preceded our protection order. And again, this is a long protracted issue. So we are asking that the court not only require the psychological evaluation with parental risk components, but also domestic violence evaluation and a substance abuse evaluation. Those should all include collateral input. Those should all be at his expense. Mr. Bondurant is here with unclean hands. He is nearly $10,000 delinquent in child support to my client. He has outstanding judgments against him from the prior matter in 2020 in this case, where he was ordered to pay $1,500 towards my client's attorney's fees. He's made no payments towards that obligation. As I outlined his financial declaration, suggests that he had a gross income of $5,280 per month. And that, again, that's filed as the attachment to my client's declaration. So we're asking that the court enter the orders that we have requested. We are asking for a contribution towards my client's attorney's fees in the amount of $2,500. And then I guess we're setting over the appointment of the guardian ad litem to next week.
Mr. Bonder, did you have any response to those requests?
Well, I mean, a couple things. I'll just touch base on a few of the things that were asked of me. For one, I find it highly stressful that somebody can recognize where I'm at when I'm sitting in a vehicle during a Zoom call, to suggest, which I was, but I might add, in a vehicle during that Zoom call. I do recall exactly where I was. And I did, within 24 hours, take a hair follicle test, and everything came back negative. Miss McLean has made every attempt. I mean, it is her job, and that's what she's paid to do, is to make every attempt to outline things that are just completely inaccurate information. I do not consume alcohol, or have any sort of issues with substance abuse problems, and that includes alcohol. That can show in the test, and that included alcohol as well. And I also included in my declaration that I'd have absolutely no problem whatsoever taking a hair follicle test at the expense of the petitioner. Because if it is a negative test, which it will be, I don't feel like I should be financially responsible for it. And I know that it will be. So that's not an issue. In her initial request, she also requested a mental health evaluation. Now, because she doesn't like the findings of that request, she now wants to up it to a psychologist and suggest that that person is incapable of doing their job and providing her the information that she wants. So basically what we're going to keep doing is we're going to keep fishing for and fishing for and fishing for until we find a psychologist that's going to sit here and say that there's something wrong that there's not. I have undergone the mental health evaluation. I released the information. I did that voluntarily. I was not ordered by the courts at that point. It was something that I had already started to do. And yes, it was something that I knew that might be a recommendation or that it was going to be requested of me. And so I jumped on it before it was even brought to the attention of the courts. In terms of the domestic violence issues, they communicate about how there is a long-standing domestic issue. The last known time that Mrs. Peterson has filed any sort of petition or claim or change or modification of any kind is piggybacking off of another case, which is with my wife, and utilizing a allegation of domestic violence, one instance, and that instance is still under scrutiny. It's something that I'm still fighting. It was a dismissed case. It was then reopened, which I find to be extremely concerning, considering it was opened 3 months later in the middle of a custody case. So I can only imagine who would have pushed the issue to have that reopened. Okay, that is the one issue. From a financial perspective, she mentions there being a judgment from a lawyer for lawyer fees. I bought a house in 2020, and I don't know, I'd assume that most of you guys understand that if there was a judgment in place, it would have been required to be paid in order for me to have to buy that house, to be able to get a loan. And I paid, and we can look back at court records, I can provide them, that I paid $20,000 that year in judgments that were sitting at Cowlitz County courthouse for things that I had unpaid. So if that was among them, it would have also been paid. Child support was something that, again, that I do have documentation that the court that it was child support cases was opened and closed multiple times. And that is where the negative balance comes from. I would have a zero balance. Then they would reopen the case and go back all the way back to the time that Ellie was 4 years old, when there was no child support there. And that's where all that is. I am completely up to date over the last 5 years on child support. And I had concurrent payments for at least 4 years, at least, with maybe a small gap of a month or two. Even during COVID, I was on unemployment, and I was being charged child support out of those checks. That is the only instance. The issue in regards to the social media thing in regards to Ellie. I don't recall following on TikTok. I very rarely use TikTok, but when I do, if I do remember my child was on there, I'm not even smart enough to figure out how to block people. But I do know that on our order of protection, it does mention, and I had to go back and I had to look at another order to kind of compare and contrast here. I do believe that that falls under the stalking clause on that, and that mentions social media and other forms. So if that was the case, I do believe that maybe a new order would need to be put in place where that stalking would need to be checkmarked because it is in another case also. Um, in regards to Ellie's counseling, she mentions that in my declaration, in hers, she mentions that she started counseling in 2020, but there was no instance where Ellie had or Tristan had ever brought to my attention that I was the root cause of her counseling. It was that she needed counseling. So from 2020 on, according to Miss McLean, she should have been undergoing counseling, which she wasn't. And in my declaration, I point out to the fact in her own declaration, in her own exhibits, shows that in those counseling reports that she was intermittently showing up, and she conveniently shows up 3 days after the allegation. That it, and another issue being is that she's going to a very biased facility through the tribe. I was with Tristan for a year or so. I'm aware of how that place works. They protect their own. I would say that it's a very, very biased assessment. If anything, if she's going to challenge my mental health, I would 100% challenge that Ellie needs to see a mental health counselor from a different facility. And that's where I'm at. I've fulfilled every obligation to the courts thus far.
All right. Thank you, sir. Ms. McLean?
Well, obviously, Ellie's been going to the same counselor for the last 3 years. So obviously wanting to have a continuity and contact, and Mr. Bondurant didn't raise any issues until today relative to Ellie's counseling. In regards to, and I'm not sure what his basis of knowledge is about a biased facility. There's nothing in his declaration that supports that. Nothing in his argument. They provide mental health services to uh, our community, and they do a good job at that. In regards to his attempt to walk around the TikTok, I think that that's a very concerning discussion that he tried to engage in. The court order, the protection order, clearly says he's to have no contact, and no contact is no contact. So it sounds to me that he has engaged in attempting to contact her in violation of that order.
I clearly said that I don't recall that happening. Sorry.
Sure. Thank you.
So we do believe, and if you go back and look at my client's initial filing, all along we've been requesting a psychological evaluation. Mr. Bondurant at the last hearing offered up that he was already participating in a mental health evaluation. Judge Evans indicated that that needed to include collateral input from my client. But he set over all of the motions for today's hearing. And we do believe, given the long history here, that a psychological evaluation with parental risk components is appropriate.
May I speak, Your Honor?
Only with regards to that last comment.
Okay.
Not the whole case, just the response.
Oh, no, absolutely. So I said that I don't recall that. Here's another issue that, and I recently decided that I was going to change my separated wife.
This is exceeding.
This is purely responding to what you just talked about.
This is.
Okay. Well, I'll hear it.
Okay. Those passwords and those logins have stayed the same for years. So people have access to those social medias. I've had absolutely zero contact. That is their only instance that they say that I violated. I don't recall in any way, shape, or form following my child on TikTok. I have followed this to a T. I have done every obligation to a T, including we're talking about this mental health evaluation, Your Honor. Okay. Again, she's referencing the fact that, yes, I identified the fact that I was going to be required, more likely than not, a mental health evaluation. I'm being docked for that. Yes, I proactively involved myself in the mental health evaluation prior to it being ordered. Yes. Had I done it prior to the incident? No. But clearly, I'm in court, Your Honor. Clearly, I have no access to my children. And clearly, I'm looking for a pathway to get those children back. Ms. McLean has absolutely no interest in me having my child back. I provided a proposal that literally gave the
Your
child
Honor, I'm going to
absolutely
object to any
everything.
Sir,
disclosures.
you're getting outside of your specific response.
Okay, I'm done.
Okay.
The only comment that I would make is that he does not
All right.
deny.
Well, I've heard from everybody. So,
All right.
so, um, looking at the temporary orders, first off on the parenting plan, I think I'm going to defer on that until after we see if there's a guardian ad litem, because there's significant requests that are contested based on the responsive parenting plan. There's already a request or an order, looks like it was signed by Judge or Commissioner Carmi on 10/25 for mental health evaluation. I think we start there. We'll see.
That's not in this case.
I understand that, but that
Okay.
also it references this case.
It does.
So I'm not going to order two different evaluations until we see if that's necessary. If there's a default entered, we don't need anything. If there isn't a default entered, then we probably need a guardian ad litem to look into the case and make some recommendations as to the specifics of evaluations if they're above and beyond what's already been ordered. As far as the no contact order, there's already a no contact order in place. And that's valid through, if I recall, I had that here. That's for a year. So that's in place through September of next year, correct?
September 11th, yes.
Right. So there's currently no access whatsoever under that order.
And my request was just simply to make sure that we had a similar order here, because the expectation is that this is the case where all of this is going to be handled eventually.
I'm just looking at comparing the two orders. So these have different provisions. Why is there different language in your proposed order than what's in the protection order?
Because the restraining order language is different than the protection order. And the parenting plan provides for the no contact. So
the parenting plan provides for no contact.
Yeah, our proposed parenting plan at paragraph 4 provides for the no contact language. The restraining order, the provisions that are adopted under that are the do not disturb, which is comparable to I guess I would argue that's comparable to the no harm. The stay away is dovetailing off of part of that no contact. And again, the no hurt or threaten is part of the no harm. Oh, and then the not contact, I'm sorry, the stay away is comparable to D, which is the exclude stay away. But your
parenting plan, it just says no contact with child, correct?
Correct. Yes. So if you take a look at paragraph 4A1, no contact with the child. And then the restraining order provides for he's not to go to her home, he's not to go to her school, he's not to go to her daycare vehicle, although technically her vehicle, but her mother's vehicle would comply with that as well.
My concern is entering multiple protection orders that have inconsistent language. That's problematic for law enforcement. It's also problematic for the courts or for the parties trying to follow these things. My thought would be is to simply have a no contact order that adopts the language of the existing protection order that was entered.
So do you want to just enter the protection order within this case?
Do
Or
what?
do you want to enter it as a protection order in this case number? Or do you want to enter it as a restraining order in this case number?
Well, I'm not sure that there's a difference as far as the police enforcing those. It seems to me they should just be consistent.
Okay. So what you're instructing me to provide for other language in the restraining order that adopts the specific language of the protection order.
That would be my preference.
Okay. So I'll do that as an in the restraining order at paragraph 5. I'll identify it as, for example, I'll just say other, and then I'll adopt the language from the protection order.
Yeah, I think you can just copy and paste that in there. That would be.
Sure.
I think that's then the rest of that order would be fine other than that.
Okay, and I'll include that paragraph 4 on the notice that Mr. Bondurant was present.
Correct.
And had notice of the hearing.
Okay, thank you. All right, then as far as the temporary order, do I have I guess I didn't see, and maybe I missed this, I didn't see a financial declaration from your client, so I don't know what the requested fee is, and I'm not sure what the basis on that is. I may have missed it. I just didn't see it.
I didn't provide, I guess I didn't provide a financial declaration. I provided sealed financial source documents. So that outlined the delinquency in his child support and her wage stub and tax return. So if the court wants me to supplement that with a financial declaration, I can do that.
I didn't see that wage stub in there. I
So
overlooked.
under sealed financial health, we provided my client's wage stub from August 4th of 23 and her 2022 W-2. So in 2022, she grossed $41,616, which is, what is that, roughly $3,800 a month?
All right. Well, I think
$3,400 a month.
I think based on that, and I hadn't seen that before, but my apologies. I looked through a lot of documents. I must have missed that one. I'm going to simply, at this point, have each party pay their own fees. At this juncture, that's not a final order. That's just a temporary level based on that information.
Will the court consider reserving my client's request?
Reserving on the temporary?
Yes, reserve for my client's request for fees on temporaries at the time of trial or whenever.
Yeah, I don't have a problem with that. I'm just not going to order temporary today. So.
Okay.
And then on the so we'll need a revised temporary family law order that has that.
Right.
And I think referencing the temporary parenting plan, since I think I want to defer on that over at least until we see if we need a guardian ad litem, because there's a lot of provisions that are in your parenting plan that are more than I'm inclined to go today based on what I have, particularly since I don't know if this is going to be a default type of case or what a guardian ad litem is going to recommend once they take a look at it.
Okay, so just so I understand then, so we're going to defer on the parenting plan, we're deferring on the guardian ad litem.
And then I'll need a revised temporary family law order and a revised restraining order.
Okay.
And we're also deferring on the default issue 1 week.
Correct. So those are all over to December 5th at 9 a.m.
Correct.
Okay. And then, do you want to set a presentation date, or do you want me to submit these ex parte?
Well, if they're agreed, they can be ex parte, but I can also set a presentation date if you want.
Let's go ahead and set a presentation date, but I'll submit them to Mr. Bondurant. If he believes that they reflect your ruling today, then we can get them signed.
You want to do the 8th or the 15th? 15th is probably safer, but
I'm out of state that day.
okay.
I could, is this at 8:45?
8th at 8:45. Yeah. And if that doesn't work, just bump it. Any Friday at 8:45 is generally fine. You may want to check with court administration because I don't know what my presentation doc looks like in January, frankly.
Okay. My preference would be the 8th at 8:45.
Okay, I'll put it on there, but like I said, if there's a problem getting it to that date, then it can be bumped to another date that works.
Your Honor,
Okay.
Clerk, I just want to advise that your presentation is 3 of 2 at this point, so this will put it at 4. Is that okay?
I couldn't quite hear that. I'm sorry.
Sorry, I just wanted to advise that your presentation docket is at 3 of 2 at this point, so this will put it at 4 of 2. Is that okay?
That's fine.
Okay.
Your Honor, I won't be available for the month of December or I wouldn't have a job. I'd have to restart my training. So where are we at with that?
I understood that he said he worked Monday through Thursday.
What was that?
Did you not indicate that you work Monday through
No,
Thursday?
Monday through Friday, the whole month. And I can provide a schedule for the courts. If there is a day there that I can make work, then I don't start until the 5th. So
why don't
I
we do this? There's not the orders that I've ordered are not particularly complex. So why don't we just note it on if there's a problem, and you'll have his schedule, and we can, find a time to do it.
Okay.
Okay.
So we're not going to do December 8th.
Well, I can set December 8th, but it looks like, he's telling me right now he's unavailable to even appear that day, which is problematic. So, I could set it probably into January, but I don't think you want to wait that long. I just don't know do you know what my presentation days are in January? To my clerk?
I'm looking.
I just, we've got a big change coming and I've got a new rotation, so I'm not.
What about this Friday, the 1st?
I'll be here on the 1st, I think. We can try that if you want.
I'm
Pretty
fine
quick.
with that.
Okay, I'm gonna put it on the 1st. That's this Friday at 8:45. Are you working on Friday, sir?
I am not.
Okay, well, let's put it the 1st at 8:45. Ms. McLean will shoot you some documents and then be back on Zoom at 8:45 in the morning, and we'll chat and make sure that they say what we just talked about.
Okay, and then I need to provide that form and is that something that's just filed to the courts, or I serve it to Miss McLean also?
Yes. Yeah, anything you file needs to go to Ms. McLean. If we do end up with a guardian ad litem, anything should also be served on the guardian ad litem. But at this point, we don't have that.
Okay.
All right, and that form is called an answer, and that's what you need to file.
Okay, perfect.
Okay.
All right,
So
8:45 Friday.
This Friday at 8:45, and then you're also going to be on the
December
5th
5th
on
at
the
9
rest of
a.m.
the issues. So you are going to have some other issues that you may want to, if your answer is filed, the default issue wouldn't be in place, but there will be likely some other things that come up. So what I would suggest, sir, would be to reach out to your employment, let them know that you have a court hearing you have to be at, or work with Miss McLean to come up with another time that potentially could work. But I'm setting it over next week for you to get that answer filed, then we can go from there.
Okay,
And
thank
Your
you, Your
Honor
Honor.
has signed the adequate cause order today.
I did. I signed the adequate cause, and I think that's all I signed today.
All right, so I'll submit a updated temporary family law order and a restraining order. Thank you.
Yes. Yep.
Okay.
then I think that leaves me with number 4 on the docket, 233-0034-108, Chelsea Bondurant and Levi Bondurant. Ms. Turnbull, I also have you on this matter.
You do.
Let me just open that file here. Okay, so in this case, we were together last on October 25th. At that time, I signed a bench order for Mr. Bondurant to undergo a mental health evaluation to assist the GAL in her ultimate recommendations, but also this court. We did allow that to be concurrent with the same obligation in another family law case. I have not received any indication of whether that's been done. So I'll first turn to Ms. Turnbull and then I'll come to Mr. Bondurant.
My understanding is that Mr. Bondurant has participated in the mental health evaluation. I have not received any results of that evaluation at this time.
Mr. Bondurant, what can you tell me about the status of that examination or report?
To this point, Your Honor, I took the intake. I literally got insurance and had an appointment made literally 2 hours after we got out of court that day.
Okay.
And that was provided to Amy Turnbull. I don't remember the exact date, but I did have the intake. It was shortly thereafter. I'm actually on my 3rd or 4th appointment.
Okay.
So I've asked there, all the releases of information are there. And the person who has like full ability to read those is only Amy.
Right.
But there is releases of information for Chelsea also in regards to like appointments being made and stuff like that. Make sure there's a follow through.
Okay. So that I'm glad that you added the release of information. That was going to be my next question, was whether you had signed that for Ms. Turnbull to receive copies. Does Ms. Turnbull have the name of the agency so she can request that if she needs to?
Yes, ma'am. And she
Okay.
also, I do believe, has the psychologist's information.
Okay.
I did, when I was at my last appointment, I asked if anybody had requested, and I don't know how it works. I'm not in that field, or I know that they are a little bit weary anytime people, they're very particular about how they release information because they want to make sure that it's completely correct because they don't want to fall into a HIPAA violation of some kind.
Mm-hmm.
So they had somebody who's a lawyer there go through it with me and made sure it was all correct and that Amy would be provided all of the information that would be required by the courts. So, yeah.
Okay. Do we have review dates set on this one yet? Don't. Not past today. Not past today. Okay. So let's set some review dates. After Ms. Turnbull, so that gives Ms. Turnbull time to review the mental health evaluation and see where we go from here. So I want to set future dates here in a second. What I'll just say, and Ms. Bondurant, I'll hear from you in just a minute too, but I just wanted to put on the record, the court did receive a declaration affidavit of Ms. Bondurant dated November 22nd, 2023. And it's not noted on for any particular docket or action. And I don't see that it was served on Mr. Bondurant.
I did receive it, Your Honor.
You did or did not?
I did, Your Honor.
You
assuming
did.
Assuming that the unstamped version is sufficient and nothing's been changed or altered to the one that's been filed, yes, I did receive it. I also actually forwarded it to Amy as well.
That was going to be my next statement, was Ms. Bondurant, what it appears to me is that you do have some concerns about, who your child is being children are being exposed to. It's not noted on for any action for me today, and it wouldn't be timely anyway if you were asking for some action, because you have to give the other party 21 days notice if you're asking me to modify something. I didn't have proof of service either, but Mr. Bondurant is saying he did receive it, so I will find that he has been served with the document. I think probably more appropriately, it's a document that Ms. Turnbull will use in her ultimate recommendations to this court. But I'll ask you, are you asking the court for something specific today? But also knowing I really can't do anything with, 7 days notice?
I was just, I had talked to Amy Turnbull, and that was a recommendation that she had told me to do, was do a declaration and then get it turned in. That way, at least it was filed. And I had also emailed it to her, from what she had told me to do, because, the findings in it were, I wanted her to take into consideration, and then I guess in the court's consideration about who the kids were going to be around in such a short matter of time, when Mr. Bondurant's telling me one thing, and then, now he's wanting to up and move with the girlfriend who he's literally saying that it's not like that with them and everything. So I just don't think it's appropriate that my kids would, I guess, possibly be around a girl who's been around 2 months, especially moving in.
I'm just looking at the temporary parenting plan that a judicial officer signed in this case. I'm not seeing any.
May I respond, Your Honor?
Just a minute. I'll come to you in just a minute. Okay. Yeah, I'm not seeing anything that would address. Sometimes in parenting plans, there's language about that the court enters about children not to be exposed to a significant other until the relationship's been in existence for 6 months or more, those sorts of things.
Well, right now he has supervised visits, so
Yeah.
nothing of that sort's in there.
Right. So I don't see that. So what I would say is I think you've done the right thing by giving it to Ms. Turnbull. Mr. Bondurant, I will come to you in a second, but I'm not making any rulings based on that declaration today. All I'm going to do today is set review dates, so that we can keep investigating what is in the best interest of the children and move forward on this case. Mr. Bondurant, what did you want to let the court know?
I have a couple small things that I would just like to address to the court, so it was on record. And I know that you obviously aren't going to rule on any of that today, but I want to make it noted, areas of concern. Number one, I have communicated with Amy in regards to this concern also, like I said, so I just wanted to bring it to the courts. So number one, this relationship that I'm having has absolutely no bearing on this case on any level. It wasn't even introduced to Chelsea. It wasn't introduced to my children. And the only person that it was introduced to was Amy, which I would imagine would never have provided that information. It was well before that. So the declaration that I did receive, and again, I know that you're not going to overly extensively look at that. However, there are some majorly concerns in there in regards to what's there. It looks like people are stalking me. There's a protection order in this.
Okay, hold on. Yeah. So I'm not going to go too far down this road. I'm not making a ruling on it, so I'm not going to take up the court's time with speculation that you're being stalked or followed. If you think that you're being stalked, harassed, or followed, that's something that you can file a protection order for, or you can report to law enforcement. But I'm not going to take up time on this docket with that. What else do you need the court to know?
Okay, and then the other thing was I was under the impression that we were going to be at least attempting to make some additions to the temporary order that would provide at least the ability to have unsupervised visits if it was solely me. This is something that Mrs. Bondurant brought to my attention, and actually, in addition to that, brought it to my children, and they're kind of looking forward to. I mean, I'm 3.5 months into this, and I honestly, I understand that this is a process, but I've undergone everything that the courts asked me to do. I've been very timely with it. I've showed up to every court date. I would really like to be able to see my children, and if by chance Amy or Chelsea may agree, I would like to see if there would be any possibility we could just make some small exceptions in terms of a couple of things. And another area would be that, like, online communication, my kids enjoy playing video games. They enjoy playing video games with their dad. It would be one area that I can still bond with them. And yeah, so I'm just, that was kind of one area that I wanted to address today.
Okay. So I'll just I know you brought this up at our last hearing. I'm going to reiterate what I said at that time. Number one, so we've appointed a GAL. We've asked for a mental health evaluation. I'm not going to be making any changes until Ms. Turnbull sees that evaluation, sees what the recommendations are, and we have some input regarding unsupervised visitation. I will note that a judicial officer in this county signed the temporary parenting plan on September 7th, and it does include 3A mandatory limiting factors on you, Mr. Bondurant, regarding domestic violence and assault. So my hands are tied essentially until I have some reason to believe that those factors are not present. So I'm not making changes today. I understand your request. You've made it before. And I think my response before, as you've noted here today, is this is a process. It's kind of step by step. I need Ms. Turnbull to have that mental health evaluation. I need further input from her. If the parties want to file declarations with this court, Mr. Bondurant, about the steps that you are taking to overcome some of those limiting factors that this court took note of back in September, please feel free to do that. So I'm denying your request today, but they are noted for the record. We are addressing them. We just need to get those professional evaluations back.
Would that would obviously include making any minor adjustments that are already there in terms of the language on electronic communications?
What language are you proposing for electronic communications?
Like the one area that I know that I think Chelsea would agree that, I mean, still is regulated. I mean, it would be like the online for like video games and things of that nature. I mean, I don't see where that would be an additional risk there. That's my opinion. I can't obviously say that, but I can't imagine that Mrs. Bondurant would disagree with that.
Ms. Bondurant, what is your position on the children having gaming time with their father online?
That is probably their one area that they do bond on, is their gaming, and it's always been a good thing and a bad thing. They've really been wanting to be able to play with him because they run in the same crowd of gaming people, and so they have asked if they would be able to play with him. And
what is your position on that?
I mean, as long as he's not asking where mom's at, what mom's doing, I would be fine with it.
What I can do is enter a bench order that does allow gaming online with father. There will be specific language stating during gaming, no chat or discussions regarding the family law case, and no derogatory comments about mother.
And then I have one other issue, Your Honor, is I am just starting a new job on the 5th. I have to have uninterrupted, and I know this stings a little bit, but I have to have uninterrupted a month. December is all going to be training. And I know I brought this issue up in another court case with another child, and it was kind of went on deaf ears. On one hand, I'm being told that I need to get my stuff together. I need to get jobs. I need to get vehicles. I need to get housing in order for things to progress forward in this case. But I can't do that without some time. So I know that, like, obviously I would very much likely would like to get through this case as quickly as possible. But on the other hand, it's a double-edged sword. So I can't show up for any court cases in the month of December at all.
I don't see an issue with that because, I mean, you're the one who's asking for visitation to be expanded. So I'm happy to put our first review into January. Ms. Bondurant, do you have any issue with that?
Not at all.
Or I don't mean our first review, our next review. Okay. That is not a problem, Mr. Bondurant. Good luck with the new position and the training.
Thank you, Your Honor.
Ms. Turnbull, what would be your proposal on, let's set 2 review dates, maybe something interim and mid to late January, and then I'm thinking February or March.
That sounds great.
Okay. Ms. Bondurant, Mr. Bondurant, it'll still be Wednesdays at 9 a.m. Anything that works better or worse for you? I think my first proposal would be January 24. So it'd be 2 months out essentially. Does that work okay?
Yes, Your Honor.
That's the earliest one, Your Honor.
That would be the first review from today.
That's the earliest in January, though, Your Honor. I mean, that's almost 2 months away just for the. What do you mean by first review?
Mr. Bondurant, you asked for the entire month of December off.
I know, no. Was there another?
Hold
Was there? Sorry, I apologize.
I'm proposing a date. If you want a different date, just tell me what date you want. That's what I'm
Well, I
asking.
was hoping for early January. I don't know if the review is that what you're talking about, where we like.
Yeah,
Huh?
where hopefully Ms. Turnbull has received your mental health evaluation. She sees that you're still doing your treatment. Yes.
Okay.
We can bump it up to January 17. Ms. Turnbull, are you available January 17?
Yes, I am.
Okay. We'll do January 17 at 9 a.m. for the first, well, the next review, I should say.
Okay.
And then let's do end of February. We'll do February 28 at 9 a.m. Okay. And then if we need further reviews from there, we can. My hope is we'll have a pretty good sense of where we're going with this case by February.
Your Honor. So does that mean supervised visits are still, or?
Yes, the bench order, the temporary parenting plan, as amended by my bench order of October 25th is the mental health evaluation. So the September 7th temporary parenting plan with supervised visitation remains in effect.
Okay.
The only addition is a bench order I'm going to do today that clarifies that online gaming with father is allowed as long as there's no comments about the family law case or derogatory comments about yourself.
Would there be able to be a bench warrant that maybe just Mr. Bondurant's allowed to attend his son's sporting events? That's been a really big thing for my son as well.
Is he precluded right now from attending those?
I'm 1,000 feet, Your Honor.
Away from me, but I would be willing if he sits. I mean, it's a pretty big building. If he stays at one end, I'll stay. He knows where I sit. I always sit in the center.
So this is regarding a no contact order, domestic violence no contact order that you all have in a different case, correct?
Yes.
So you would need to, so I can't modify it on this docket with a family law order. I don't see any reason a court would not approve that modification, but one of you would need to file for our Monday civil protection order docket, a request to modify to allow him to attend sporting events, even if he incidentally comes within 1,000 feet of you.
Okay. And then would he have to go to that? Because if I do it, he's not going to be able to obviously go because of his new job. Would he have to go, or is this just something that I can do and then I can just let him know through the app?
If you both want to submit, we don't usually do it this way, but I do protection order docket. So if you both want to submit an agreed modification order with agreed language on the sporting events and you both sign it, I have no problem doing that change off docket for the two of you, but I would need to see that both of you have signed it and submitted it directly to my attention. It's called, you would be filing it ex parte. So EX space PARTE to my attention. So if you both want to agree on that language and submit it, then we don't even need to hear it on docket. If you don't agree on the language, then yes, one of you needs to cite it on for a Monday protection order docket, and then both of you would need to be present.
Well, the only
Okay.
thing is on that is I would want it to be just Mr. Bondurant going. I don't feel like any other person would
Yep.
need to go.
So
But he's not
again,
gonna agree to that.
yeah, so again, well, I think what you need to be careful there is that the court under protection order doesn't have any jurisdiction over anyone else but the parties in the protection order. So I would not be able to preclude other people from being at a sporting event because it is a public event. But like I said, if you guys agree on language, submit it to me. I can get that done for you. If you don't agree on the language, then one of you needs to note it on for a Monday protection order modification hearing, and you both need to be present. And it is still on Zoom, so. That's
If one of us submits it and the language is to modify it, we both have to be present, is what you're saying, Your Honor?
yes. If you don't agree on the language, if you don't submit an agreed modification order, then if you don't agree on the language, it's got to come up on a Monday 9 a.m. protection order docket hearing.
Okay.
And then the court would make a decision about what the language should be. Okay, any other questions for me?
I don't believe so, Your Honor.
Okay. So we have you back January 17, February 28. Ms. Turnbull does now know that the ROIs have been signed with mental health. So that's good. I'll do the bench order for the gaming authorization, and then you all have some information if you want to amend the protection order. Anything else?
Your Honor, I do have one more question.
Yes.
Mr. Bonner had expressed some concern when the mental health evaluation comes out about how that information gets disseminated and who has the ability to access that information and then where that information might go. Typically both parties would get a copy of that. And I know the other case that may be the case, that may happen as well. Can we have some sort of agreement ahead of time about how you would like me to handle that information given his concerns?
Yeah, so Mr. Bondurant, is your concern that you don't want Ms. Bondurant to have the mental health evaluation physically, or you tell me what your concern?
I think I 100% endorse mental health, and I know that I've neglected it over the years. However, I'm willing to do everything that I need to do for myself. However, a part of that is taking into consideration the fact that I was audibly concerned to Amy initially when I was signing the ROIs because there wasn't a specific language by the court as to what needed to be presented. I just knew that ROIs needed to be released to individuals. And I don't trust that my information is going to find its way onto social media platforms, that it's going to find its way to other people to arm themselves in other ways. And that's concerning to me. And really realistically, it makes me feel like I can't be comfortable with the person that I'm speaking with. And like I said, I've been completely transparent with my counselor in kind of good faith that the information would end up being released, in a way that was protective to me, but also maintained the relevant information that needed to be provided for the courts and Amy. But like the things that I don't believe need to be necessary are what the diagnosis is, unless it pertains to child at risk. As long as Amy knows and knows what we need to do to, mediate around that situation, or he needs to continue counseling or medications that he needs to be taking. I have no problem releasing information on medication or treatment dates, or making sure that I'm still attending. But I don't think that like literature inside of that would be necessary to have for anybody other than a counselor and the relevant people.
So I think what I can tell you on this is that anything that's filed with the court for review is filed what's called under seal, meaning it doesn't become a public record. So if someone were to request anything from this case, that your mental health evaluations don't become part of that. So,
but if there's a release of
well,
information to Kelsey, sorry.
Yeah, let me finish. So I understand your concern to some degree. I think some of it might be, you might be hypersensitive to some of this. I don't know how realistic some of your concerns are, but I hear you. And the best I can tell you is when it is filed with the court, it is under seal. Ms. Turnbull only releases her report under seal. So in discussion of specific mental health diagnoses, that is also kept under seal with this court. So I'm not quite sure how to fully address your concerns while also.
So that release of information is very specific to
I'm not
Kelsey.
sure. You keep interrupting me. Just wait, please. I also just need you to know that the court has to have this information to decide what is healthy and safe for your children, given that there are 3A and 3B limiting factors that a judge has found. So we do need your diagnosis. We need your treatment plan. We need to know if your counselors think that there's a safety concern for the children. And the other parent in this process is entitled to know that too, so that they can advocate for best interest of the children. Now, I can tell Ms. Bondurant, absolutely under no circumstances would the court condone redisclosure of any medical information, especially mental health, that you receive of Mr. Bondurant's. I haven't seen that be an issue in this case yet, but I'm happy to say that on the record to Ms. Bondurant so that she knows the court does take your health privacy very seriously. Beyond that, I'm not sure what else you're asking for.
I'm concerned. I'm not concerned on the diagnosis. I'm concerned on what is personal stuff that I share. Basically, if I give full access, a release of information that gives full access to details to what is talked about, that's not a diagnosis. So I need very specific. I don't think that for somebody like Amy to sit here and go through the documentation and say, okay, this is relevant, this is irrelevant, this is so on and so forth. But hypothetically, if there's a sexual assault in my past that I don't want to be presented to her in a legal document that she can, whatever, I don't think that that's something that I need to release to her. The diagnosis, yes. And in that, like I'd imagine in those reports, right, by the guardian ad litem, it's going to be sensitive to that and obviously put into a report eloquently. But there's a lot of childhood trauma there that I don't need to be on paper. That I don't need there to be like the summaries of it or what I'm communicating about or things of that nature, unless it's relevant to the diagnosis. It's not very specific. It just says release of information. I mean, to the psychologist, that sounds like to him that anything that she asks, he has to provide. It's not specific.
Well, again, you are right. I mean, that is what the court is requesting as part of a full mental health psychological evaluation. And again, what I can tell you is we filed those under seal. Ms. Turnbull files her reports under seal, so it doesn't become public information, but I think that's the best I can tell you. I'm not gonna make a ruling that tells a mental health professional what can and can't be shared from your sessions. I think that's far outside my scope.
I mean, I understand it being shared with the courts and Amy Turnbull. I don't understand why it's parent specific.
Okay. Well, you have my ruling. I'm not
Okay.
doing any limiting factors on what is in the reports. Is there, beyond that, is there anything else we need to do today?
No, Your Honor.
Ms. Bondurant, anything?
No, Your Honor.
Okay. All right. We'll see you back on January 17th unless one of you has an issue and notes this back in sooner. Okay.
Thank you, Your Honor.
All right. Thank you all. You're free to log out.
Perfect. Thank you.
Good morning. Can you hear me out there?
Yes. Sorry, I was still connecting to audio.
Mr. Bondurant, can you hear us?
Yes, Your Honor, I hear you.
Good morning. We're started just a little bit early because everybody's here, so I do have proposed orders. Did you get a copy of those, sir?
Yes, there's a couple reasons why I didn't sign one of them, but I couldn't sign the other order or the other documents. I wouldn't sign one of them. So I did get them though, Your Honor.
Okay, so what issues do you have with? I'm looking first at the temporary family law order.
It looks like everything is correct, but it looks like Miss McLean tried to sneak in a new brand new year on that order without utilizing the original date.
On
I think he's referring to the restraining order.
that may be
His email.
yeah, that may be. I don't see any dates on the temporary order.
I mean, the original protection order, Your Honor, started in August, and I was kind of curious as to how the expiration managed to be in September, but I kind of like let that one go. But I think I got Houdini'd on one extra month again when she put in the temporary restraining order or for part of the parenting plan. But the original protection order is the date that I thought we were going off of, but I guess I'm wrong.
Again, I think he's referring to the restraining order at paragraph 3. The court did not indicate that you were identifying a specific date or changing that provision at the time of the hearing. You ordered me to change the language first off at 4 under notice to reference that he was present for the hearing. And then at number 5, you ordered that the language identify or be the same as the protection order. So 5A, 1, 2, and 3 is the language that is from the protection order. There was no argument about paragraph number 3 or establishing a specific date.
Normally on these orders that are in the course of a dissolution, they generally are set to go through the course of the case. But the state requires that we have an end date of some date. So this order would, if the case concludes prior to 12 months, it would have to either be renewed at that time or ended at that time. But the 12 months is not that's not adding anything. This would not normally expire at all as long as the case is pending.
I'm confused, Your Honor. Does that mean I have two separate expiration dates? I would have the family the temporary restraining order and the protection order. There would be two separate.
That is actually correct, sir. It's problematic having two orders, but that unfortunately is how the state of Washington has decided to set up their structure. But the language in this order appears to be the same as in the other order, which was really my concern, is so that we didn't have different language as to what the order was saying. So,
well, it is critical for me to understand when things expire, though. Otherwise, that's how I put myself into bad situations a year from now.
Well, this one is 12 months unless it's renewed.
Okay, but when does it expire? When does it expire, though, naturally, if this case is dissolved?
It would expire if the case was dissolved unless there is a new order entered in those final orders. So it's either at the end of the conclusion of the dissolution matter or at at 12 months from today. And then if there's a request for this to continue beyond that, that would have to be addressed separately. That's not in front of me today.
Well, like I said, right now, there's no reason. There's no. I can't see the child, so I mean, it doesn't. As long as it falls off eventually.
Mm-hmm. Yeah, it does. Like I said, the 12 months is just the state sets that up as a default, and normally in a case like this, there wouldn't be an expiration date, except if we don't have that, then law enforcement has challenges managing them. The state, they want an end date. So
okay.
So that's not something anybody's. That's just normal. So, and again,
Okay,
if it's done prior to that, then this order would end, and unless there's a new one, there wouldn't be one unless there's a new one issued at that time. So okay.
Yep.
Everything else look all right?
Everything else looks fine, Your Honor.
Okay. It looked right to me. So but I want to make sure. So let me tell you that. Please, the first.
Yes, sir. 12-1.
What happened? Serious, I don't know what happened to the month. So on the other order, the temporary order, the only thing really in that order is that it sets over essentially everything to next Tuesday, defers fees until future requests are reviewed. So that one all right?
What was that? Yes, Your Honor.
Okay, all right. So I've signed those two orders and they will be filed a little bit later today. We're over at juvenile today, so I don't know what time those will actually hit Odyssey, but
we will provide Mr. Bondurant with a confirmed copy by email once we have those available.
okay, so I have signed those and those are going to my clerk right now.
Thank you.
Okay, Your Honor, I do have one quick question though, actually. So remember we mentioned that on the 5th that we would have a court case. I was going to ask if it would be possible to move us to the top of the docket. I actually don't start work until 10 o'clock that day. And if we could be managed to squeeze our case in early on that day, I'd be able to do both. So I know that I could probably only I can only request it, but I mean, that's my request.
It won't be my docket, but we'll put a note on the case and I believe it'll be Judge Evans. He can see that and he's pretty good at managing that docket. So if one of you can make some noise at the beginning of the docket and request that, and it'll typically be handled.
Awesome. I thank you, Your Honor.
Okay. You also have a good weekend.
Name Bondurant v. Peterson, cause number 13-3-00206-4. I see that we have Ms. McLean online. And sir, is that how you say your name?
Bondurant, Your Honor.
Okay, I'll probably misstate it again. I apologize.
It's okay. It's okay.
All right.
We were before Judge Basher, I think it was last week or the week before. He, if I recall correctly, entered the order on adequate cause. He entered a modified temporary order and a restraining order. And he set this over for the determination of a parenting plan, a default, and referral to guardian ad litem. In the interim, Mr. Bondurant has filed a response to the petition, so we would withdraw the request for the default. However, I would ask that the court take that into consideration as it relates to my client's request for attorney's fees. And then as it relates to the actual parenting plan and guardian ad litem provisions, we are obviously the court's had an opportunity to review, at least through the history of this case. This case started with a protection order, which is still in place. That was entered on September 12th of 2023, and that protects Ellie, who's 14 years old, from her father at this juncture. Ellie, unfortunately, has been exposed to domestic violence within her father's household. And Ellie has obviously at an impressionable age. Our position is that Mr. Bondurant should be modeling appropriate role type or an appropriate parental role to his child. Instead, he has engaged in domestic violence, substance abuse, which is primarily alcohol, untreated mental health, and instability in all aspects of his life. If you go back and look at the findings from the protection order, and that was a contested protection order hearing, at that time, Commissioner Carmi found that Mr. Bontrant is a perpetrator of violence within his household, and that Ellie experienced anxiety, apprehension, worry, and that she engaged in preparing a safety plan with her own mental health provider because of the exposure by her father. During the most recent domestic violence incident, Ellie was directly involved. And during that incident, Mr. Bondurant interfered with what he perceived to be Ellie's reporting of the domestic violence to 911. The domestic violence was occurring. Her stepmother, Chelsea, had hollered down the hall for her to call 911. Ellie was so scared of what potentially her father would do that, in fact, she texted her mother, Ms. Peterson. When Mr. Bondurant saw that she was on her phone, he grabbed it and threw it, which, at least in his mind, he's interfering with the reporting of a 911 call. And then when he found out that she had texted her mother, he demanded that she text her back that everything was fine. Shortly thereafter, Ellie's stepmother was able to remove Ellie and herself, and I believe the other children, and she took Ellie to her mother's home, where Ellie was distraught. She was crying so heavily that she was hyperventilating and having difficulty forming words. She was immediately comforted by her stepfather while her mother was trying to get information from Chelsea, the stepmother, to figure out what had occurred. Ellie has disclosed to her counselor about the struggles with her father's behavior. She's described their relationship as negative, poor, and non-existent. And Ellie's relationship, quite frankly, appears to be more strongly bonded with her stepmother and her half siblings. Since Ms. Chelsea Bondurant's initial protection order, which was entered earlier this year, Ellie was exercising her father's visitation with the stepmother and the siblings rather than with Mr. Bondurant. Mr. Bondurant did not exercise his summer visitation this summer. And it is concerning about Ellie's, again, information that she provides to her counselor, which we provided in the counselor notes. Mr. Bondurant claims that he was not advised when Ellie was first engaged in counseling. We provided in my client's reply documentation the text message that shows back in 2020 their communications about my client's concerns and engaging Ellie in counseling. And then, of course, obviously, we weathered the COVID pandemic for the last several years. And obviously, when you have a child, particularly a teenager, who's saying that they need some emotional support, in this day and age, you can't take that with a grain of salt and you need to take action. And that's exactly what my client did with full notice to Mr. Bondurant. Mr. Bondurant, despite being advised by my client about the difficulties that Ellie has expressed with him, has not participated in any type of counseling with Ellie to try and rectify those issues. And Ellie is saying at this point, she does not want to have a relationship with her father. She's afraid of him. He's put her in too many difficult situations. One of the other situations that's prominent is Mr. Bondurant being intoxicated and demanding to be able to drive Ellie and her older sister while he was intoxicated, and Ms. Bondurant Chelsea having to step in so that these children were safe. Mr. Bondurant has a long-term mental health history that is not currently being treated. He does have a prior attempt in 2018, which resulted in a uh, an ITA to St. John's Hospital. And shortly after that, there's been no indication that he has continued with his own mental health counseling, his own medication management, and the like. What we are asking is that the court enter a parenting plan that provides for continuation of no contact. If you look at the documentation that has already been entered in the active dissolution case with his current wife, Chelsea, the temporary parenting plan entered in that matter has already entered 191 findings against Mr. Bondurant for domestic violence, assault, and emotional or physical problems. We're asking for those same findings, as well as a finding relative to substance abuse. It's our position that Mr. Bondurant should be evaluated for those concerns, and that those evaluations should include a psychological evaluation with parental risk components, a domestic violence evaluation, and substance abuse evaluation. And those should all be collateralized evaluations with input from my client. And input from the guardian ad litem, assuming the court appoints one, as well as input from Chelsea Bondurant, who has been his spouse for the last several years. He should also be required to start any recommended treatment, and evaluations, treatment plans, and the like should be provided to the court under seal and all parties, and those should be at Mr. Bondurant's expense. As it relates to the last time that we were here, actually, I guess it was 2 times before, Judge Evans had indicated that Mr. Bonner was required to provide notice of who his counselor was that he was going to be doing an evaluation. He had made a representation about an evaluation. There has been an order in the divorce case with Chelsea that he undergo a mental health evaluation. And he had disclosed to us Mr. Dillagrange at Core Health. He provided that information timely. My client has provided some input to Mr. Dillagrange. I don't know Mr. Dillagrange's qualifications. I don't know if he's doing a psychological evaluation or if he's simply doing a mental health evaluation. But given the long-term history, we think it's appropriate for there to be a psychological evaluation. We also have not received any follow-up evaluation or results from Mr. Dillagrange. So we're asking that the court enter the 191 factors that have been proposed both in paragraphs 3A and 3B of our proposed plan. We're asking that the court also take into consideration that, again, my client's request for attorney's fees. We are asking for a contribution of $2,500. We did file the default motion because he had not filed a response to the petition within 20 days. I would also note that he's here with unclean hands in that he's currently about $10,000 in child support arrears. He also has an outstanding judgment against him in this court for an outstanding attorney fee award owed to my client for $1,500, which was entered back on October 21 of 2020 when his adequate cause motion at that time was denied by the court on initial motion. If you go back and look at the attachments that I provided from his divorce case, his financial source document indicated that earlier this year, he had grossed $15,840 between January of 2023 and April of 2023. That provides him with a gross of $5,280 per month. I have provided my client's wage stub and current wage stub that we had when we filed this matter for 23, as well as her 22 W-2. Her net is about $4,300 per month. Obviously, she's taking on 100% of Ellie's care. And we're here because of Mr. Bondurant's behavior. So we do believe that it is appropriate to award my client $2,500 in temporary attorney's fees. Assuming that you do decide to enter a guardian ad litem order, I have provided that to you. We would need to make some changes to the proposed date since our hearings have been set out, and that would be on page 3, and I can walk you through those at the time of your ruling if you decide to appoint a guardian ad litem.
So Mr. Bondurant, I'll hear from you in just a minute. I wanted to first take care of the order regarding the default, so it's taken care of and not missed.
Okay.
Bottom line is I've stricken some parts out of it with the final order being the motion for default is denied. The other party basically, bottom line, has responded, so not in default. So Mr. Bondurant, any objections to my signing off on that order?
No, Your Honor.
Okay.
Your Honor, would you also make that change on page 1 up in the heading where it says granted? And just change that to denied.
Oh, okay.
And I assume you struck the last sentence of paragraph 9.
Okay, so what I've done on paragraph 2, I have stricken the word not, and in paragraph 9, I have stricken the word granted and put denied, and then entered the other party, Levi Bondurant, is not in default, and then have stricken that next
Perfect.
line.
Thank you.
All right, so that one is done. All right, sir, go ahead. And what would you like to tell me?
First of all, Your Honor, like I said, I've made it to every single court date thus far. I filed every piece of documentation that's required by the courts. Maybe, like I said, I'm not an attorney, so I'm doing my best to try to put things in a timely fashion and and as professional as a manner as possible. I've supplied the courts with a declaration that I'd hope that they would use as a source of information in regards to the situation. Mrs. McLean mentions a history of domestic violence. My question to the courts would be where is this factual information at as to a long history of domestic violence? There is none, Your Honor. It's all hearsay. In terms of substance abuse, Your Honor, there is absolutely nothing in the courts to show any sort of instance of substance abuse. Matter of fact, the judge, a previous judge, ordered a hair follicle test. It was not done the same day. The judge ordered it the next day. I did get it the next day because that's when the funds would be available and when I would be in town. And I took that test, passed the test, and I have no history of DUIs. I have no history of a failed drug test in any courts. Matter of fact, through the Department of Corrections that I spent 3 years on, I never failed a UA, not one time, or was violated. So there is no history of substance abuse, and that includes alcohol. That was on the panel that was provided to the courts. There is a allegation of domestic violence, and I take that very seriously. I am doing everything that I need to do in terms of the legal side of it, the criminal side. I don't want to speak too much on it, Your Honor, because there is still a criminal case in regards to that.
So I want to make sure you understand your right to remain silent and not talk about if with the pending criminal case. All right. You
Absolutely.
understand that?
Yeah.
Okay.
Yes, Your Honor.
All right.
So I, like I said, I don't want to touch too much on it. What I will say is that the information that Noelle McLean has
is not reflective to many different statements and police reports. As we were to go along a little bit further, I think if a guardian ad litem would be appointed, the guardian ad litem would be able to look at some of this documentation and would be able to see that there is a lack of information and that Ms. McLean is either Noelle McLean or Tristan Peterson is fabricating information to make this look much more dramatic than it really is. I do, again, take it very seriously, and I've been here every single day that I needed to be. I'm just now starting work again. I've been unemployed for almost 6 months. So those financial declaration paperwork is not reflective to what's going on. Like I said, I actually start work here in 20 minutes. And I'm sitting in the parking lot as we speak. I've undergone the mental health psychological evaluation that was required in another court. A guardian ad litem was appointed in that court also. So I would ask that a guardian ad litem be appointed.
Is that in this jurisdiction? Is it in this court here, your other case?
Yes, Your Honor.
Okay, who's the guardian ad litem in that matter? Who's in that case?
Amy Turnbull, Your Honor.
Okay. All right, go ahead. Anything else?
Your Honor, I supplied a parenting plan. I've done everything in the best case for Ellie as things are presented to me. I'm not perfect. I'm not trying to pretend that I am. I've made a series of mistakes in my life, and I've done things to rectify them. I've shown the court that I'm willing to continue to keep fighting and keep bettering myself. I presented Ms. McLean with a parenting plan that literally provided me with no visitation. I did that because I felt like it was if it was in the best interest of Ellie, then the literature in that presentation of that particular parenting plan is that any visitation with me would be completely at her discretion. And that was not good enough. So I don't know what else Mrs. McLean wants. I've jumped through all the hoops. She wants me to go through a mental health evaluation, psychological evaluation. She wants me to do substance abuse stuff that I'm not literature. I don't even understand most of it. For what? For me to not have any visitation of my child? That's basically what she's asking for. She wants me to jump through endless hoops, and there's nothing in there that suggests that she has any desire to bring my child potentially a relation or rebuild a relationship back up with my child. So at the end of the day, I don't know what to do. There was an earlier case with Ellie when we originally started the visitation process. I don't recall the year, Your Honor. The guardian ad litem in that report provided me much more time than that I ended up taking. Mrs. Peterson actually told me that it was going to be in the best case of Ellie if we integrated it slowly. So I went to every other weekend, and I've been like that for the last almost 10 years.
Seems to be exceeding the scope of the declarations at this juncture.
All right. So anything else that you want to add? Okay.
No, Your Honor.
Anything in response?
Just that the child has reported more than one incident of being exposed to domestic violence. Chelsea Bondurant's declaration that we provided as an exhibit to my client's initial motion declaration in this matter, as well as my client's husband, Ryan Poss declaration, all speak to Ellie's behavior, being distraught about her father's behavior and what she's been exposed to. Chelsea Bondurant discusses multiple instances of domestic violence that Ellie has observed and been exposed to, as well as Mr. Bondurant's alcohol consumption concerns. So we stand by our request.
Your Honor, if I may say something.
We're done. We're done. Okay. All right. So here's what I'm going to do. First off, I am going to appoint a guardian ad litem, and my thought is to have the same guardian ad litem. It seems like it would be, having two different ones, I'm not sure makes sense. That's what I would propose. Any objections to that?
No,
I
Your
don't
Honor.
have any strong objections to that. I don't know about my client, but I understand the court's position.
Okay, so I am going to appoint Amy Turnbull.
Turnbull.
How do you, Turnbull.
Turnbull. And then, so that's at the top of page 2.
Filling that in.
And then at the top of page 3, the 120 days that's identified as February 29, 24 needs to be changed to April 5th of 24.
Where are you looking?
Line 2. It's the second.
Page, 3.
Page 3.
So
change the 2/29/24 to 4/5/24.
Hold on. So I haven't used these for a while. So page 3, the top, the 30-day review would be when?
No. Okay. So the 30-day review would be January 9th of 24.
Okay. And
The final G would be April 16th of 24. And if you go above, you see where it says deadline, and then the second line says 120 days, February 29, at the very top of the page. So this is the guardian ad litem's 120-day deadline of when their report is due. It's above where we were just filling in the dates.
Oh, there it is. Okay.
So change that one to April 5th. And we are asking, so I will tell you that I wasn't aware of Mr. Bondurant's fees when I originally provided this at county expense. I know that he apparently he claims he's been out of work, that he's now got work. Of course, so I provided at paragraph 10 as far as county pay. Obviously, my client is asking that if you allocate any portion to her, that hers be county pay, given the fact that he is so far behind in child support, and she now has 100% of the responsibility for Ellie.
So at this point, I'm going to do 100% county pay. It sounds like the father has just gone back to work. I don't know what his pay is. It is subject to change later. So if we find out that you're making good income, then that's going to change. But for now, I'm making it county pay. Okay. So, and then, okay. So, sir, are you okay if I put approved via Zoom on this one?
Yes, Your Honor.
All right, and then you'll need to sign off on release of information since I don't have your signature on this order. It does have the child's signature and the mother's signature. So you'll need to get that to the guardian ad litem and make sure to sign so she can get your documents that she needs, okay?
Okay, Your Honor. Thank you.
All right, so that guardian ad litem order is done. So now the parenting plan.
And I'm sorry, I'm sorry, may I take you back to the GAL appointment order?
Sure.
On page 5, I had Mr. Bondurant's old address. He's since moved again. So if we could just update that.
All right, I made that change as well. So get a hold of Ms. Turnbull, let her know that she's been appointed in this case as well. And then in regard to the parenting plan, I think the easiest thing is to go through this, and then let's see.
Your Honor, if I may, just
Hold
wanted
on.
to let you know. Okay.
Yeah, go ahead.
I just wanted to remind the court that I actually have to go into this in about 10 minutes. So
I'm
hoping
trying
that-
to go through this rather quickly.
Okay.
All right, so in regard to the limitation paragraphs, number 3, I'm going to reserve those. Going to paragraph 1. So it's very clear, and Ms. McLean, I know you can always bring a modification, but I put it subject to modification after recommendations of guardian ad litem. So I want the dad to understand that. So this is for now. All right. In regard to the limitations or the 191 factors, at this point, I'm going to reserve. I am going to leave in about the urinalysis and the hair follicle and that for now. On 4A, 2B, both shall be enjoined or restrained from talking negatively. As to the evaluations, again, I'm going to reserve for now because I want input from the guardian ad litem. And when you talk to Ms. Turnbull, I'm looking for her to have some input by that 30th day. So when we have that first review, if she can just have some input as to those evaluations.
And is it possible that you can provide that or write that in on paragraph or page 3 of the GAL appointment? Just GAL input on evals.
And I'm hoping because she has some contact via the other case that's where that 30 days will be enough time.
Okay.
All right, and then I'm leaving the decision-making as proposed for now. And then reasons for limitations at this time. There is a DV no contact order in place, correct?
There is a protection
Yes, Your Honor.
order.
Protection order.
And a restraining order in this.
Okay. So I'm reserving what's here. But ordered because of DV protection order. At this time.
All right. We will
All right.
provide Mr. Bondurant with a conformed copy once those are available on Odyssey.
Okay. So for now, it's this. I'm really looking for input from the guardian ad litem. I am ordering the rest of what's here at this time.
And then there was a request for fees. Do you still have a temporary family law order there?
I don't have a family law order. So in regard to the fees at this time, until I have current financial information from the father, so you need to get that provided and filed, okay? I'm reserving on the
Okay, Your Honor.
fees pending current documentation of finances. All right, sir, are you okay to put approved via Zoom on the parenting plan at this point?
Yes, Your Honor.
Okay.
So then may I schedule a presentation date for that temporary family law order?
All right. I believe Fridays at 8:45. Fridays at 8:45.
Okay, what about?
I can't have any.
Okay. All right, so we can do it this Friday or the next Friday.
This Friday's fine.
Okay.
I'll get it.
Your Honor,
emailed.
If you don't,
Your Honor,
okay,
sorry.
just listen up real quick. If you agree with the order that she proposes, you can sign off on it, and then you won't need to appear on Friday at 8:45. But if you
Okay.
don't agree, and it's just what I ruled, nothing more. Okay.
Okay. Perfect. Awesome.
All right.
Thank you, Your Honor. That's all I needed for clarification.
All right, that's it for today.
Thank you. Noel McLean appearing on behalf of the respondent, Tristan Peterson.
All right.
This is Amy Turnbull, the guardian ad litem.
Okay. And I believe we have Mr. Bondurant. Am I saying that correctly? I'm not hearing you.
Pretty close. Yes, Your Honor. I apologize.
Okay. All right. So he is here as well. So this is a check-in to see where things are. We have a guardian ad litem order that was filed on December 5 of 23, 100% county pay. So Ms. Turnbull, any report, anything you can tell us at this point?
I have made contact with both parties. They are being compliant. Mr. Bondurant has engaged in a substance use evaluation, and that the process of collateralization is in process. I have notified both Chelsea and Tristan from this case and a separate case that they can proceed with that. Mr. Bondurant has agreed to do a domestic violence evaluation, and I have put him in contact with Olivia Lovely So that should be moving forward. We do have some concern about the mental health evaluation. He has had a mental health evaluation with Cowlitz Family Health Center or Health Clinic. I have not received those records. Mr. Bondurant has a history of trauma that he wants to protect. I think he's had some experiences with that being put out into social media, and he wants to have some privacy around that, and he's concerned with those records being released, that information is going to get out. And so I think to some extent his provider is trying to protect that. At the same time, I have not been able to receive it. Mr. Bondurant has signed an ROI. I've sent over an ROI and a request for records, and I've received nothing. I think Mr. Bondurant does not want me to have the assessment. At the same time, I'm a little bit concerned without the assessment. I can't fully appreciate if the diagnosis and treatment recommendations are, how they've been come to, so to speak, and if the provider is fully evaluating or adequately evaluating his history in light of some of the things that we're looking at here. So I don't know if Mr. Bondurant wants to speak to that, but I would like as much access as possible, but while also respecting his privacy. And we've been hung up a little bit on this issue.
Mr. Bondurant,
Yes, Your Honor.
anything you'd like to say at this point?
I did reach out to the provider. It's less me and more the provider. I don't know the legal ramifications of these providers giving full disclosures. I think that the issue being is that we're not sure the specifics of what it is that they're asking for. I know that the day that I originally signed a release of information, I must have had 3 or 4 people there. I would assume one of them being an attorney, just to ensure that that release of information was going to be reflective to what the court's requiring, and making sure that nothing else is being put out there for anybody, and to make sure that it's being, put in the right hands, I should say. And there is a lot of childhood stuff that I can't say is relevant or not relevant to this particular case, but there are things. There's been a history of some of my information finding its way onto social media platforms. This is something that was mentioned into my assessment. So I think that the psychologist believes that he's just protecting that some of that information. It's not that they're trying to prevent things like diagnosis being out there, or continued treatments or any of that nature. But some of the more sensitive information, he's hesitant and not exactly sure exactly what it is that the courts are asking, and would like more specifics before providing that information. He'd rather provide less, if that's what's required, than sending off all of it and then not all that needed to be out there, if that makes sense, Your Honor. So we're kind of just in a kind of a weird spot where I don't know exactly what to tell them and what they're comfortable with sending over, or what the process there is. But I sent a message over to him saying, if this is going to be something that's going to hold up, if my information being leaked or, being out there that for people's eyes, it's worth the risk to me to get my kids back. So I'm going on 6 months at this point almost. So yeah, I don't know where to go from there.
Ms. McLean?
So this is the first time I'm hearing a lot of this information. I am a little bit blind because I haven't had an opportunity to speak to my client about these issues. Last time we were before Your Honor, you actually had reserved in the temporary parenting plan for additional feedback from the guardian ad litem today as to whether or not there were additional evaluations and treatment that was going to be necessary or required of Mr. Bondurant. At the time, it was disclosed that he had an evaluation scheduled with Mr. Delagrange at Core Health This is the first time I'm hearing about him now participating in an evaluation with Cowlitz Family Health Center. So I don't know who that provider is. I can't tell the court if my client has been allowed to provide collateralized information to Cowlitz Family Health Center, but I am aware that she had reached out to Mr. DeLagrange some time ago through Poor Health. The allegations as far as information going out on social media, I'm not aware of my client having done that in the past or doing that currently. Obviously, information that comes about through a court action should not be disclosed through social media. I think that that should be across the board as far as information for both parties, that anything that's happening in this court action should not be disclosed on social media. We had originally asked the court at the time of our motion that the court require Mr. Bondurant to participate in a psychological evaluation with parental risk components. In my initial discussion with Ms. Turnbull and the information that I had forwarded to her, I did outline at least my understanding through my client of Mr. Bondurant's mental health history and the concerns that I was not aware of the qualifications or credentials of Mr. DeLagrange at Poor Health and whether or not he was qualified to perform a psychological evaluation with parental risk components. So at this juncture, I don't know the level of the evaluation or the collateralization or who the provider potentially is at Cowlitz Family Health Center. And I don't know the qualifications of Mr. DeLagrange. So I guess I need some more input as it relates to Ms. Turnbull and the court on what we're going to do with reference to whether or not there needs to be a psychological evaluation as we had requested. This is the first that I'm hearing that Mr. Bondurant had agreed to participate in a domestic violence evaluation as well as a substance abuse evaluation. Again, those were evaluations that we had requested. And if you take a look at page 3 of the temporary parenting plan that was entered on December 5th of 2023, you reserved that for input from the guardian ad litem regarding the needed evaluations. So I guess I'm hearing from Ms. Turnbull that she does believe it is appropriate for him to participate in a domestic violence evaluation as well as a substance abuse evaluation. Again, this is the first I'm hearing of this, so I would need to know who those providers are so I can appropriately instruct my client to provide collateralized information because she does have information relative to those issues and concerns. So I guess at this point, we would ask that the court to order that he is to participate in those evaluations. Again, I'm a little flat-footed as it relates to this mental health evaluation or psychological evaluation and potentially whom that provider is. But I would agree that information from those evaluations and whatnot should not be disclosed on social media or outside the purview of this court hearing. And that should apply to both parties.
So one thing, and I'll get back to Ms. Turnbull here in a minute. One thing that I do want to make sure is understood at this point, because of COVID, there were a number of dockets that were put on Zoom, and because of closed courts, we had to go on YouTube to be in compliance with the open courtroom. That said, we have changed that this year, so I am no longer streaming family law cases. We are here, a person can come and be in person, the courtroom is open. And so I don't know if maybe that's what they're talking about as far as getting on social media and the streaming. I don't know, but just wanted to raise that and bring that up. That said, Ms. Turnbull, at this point, what evaluations are you recommending?
The substance abuse evaluation, the domestic violence evaluation, and minimally a mental health evaluation. I'd like to see what he's already completed Um,
Okay.
and then, potentially an additional mental health evaluation. I don't know the credentials of Mr. De La Grange and what the extent of the mental health evaluation that's been done, because I haven't seen it. So I'd like to reserve and, potentially have a mental health evaluation by a PhD level provider, depending on what's already been done.
So going
Sorry.
to the records and getting them disclosed, at this point, if you sign the release of information, obviously they want to make sure it's knowing. And maybe if they understood what I said about this is not streamed, this is as if you're in the courtroom, you're just appearing via Zoom. That maybe that's what they're talking about. That's the only thing I can think of, but you signed the release of information. I expect the information to be provided. That's the whole point of having a guardian ad litem, is to be able to review that and say whether or not make a recommendation. I agree that there needs to be an order. Basically, anything involved in this action shall not be disclosed beyond the guardian ad litem, the parties, any attorneys that are involved, and the court. But that's as far as it should go. It should not be disclosed to any other third party or on social media of any nature. And so Ms. McLean, can you draft and put together and basically an order of that nature so it's clear?
I can. And would the court also include providers? Because I'm assuming particularly if there's a dual diagnosis, that there would need to be a sharing of information between providers as well.
Yes, that would be appropriate. And then I do want to have the substance abuse evaluation. It sounds like that's being done. Domestic violence evaluation, at least a mental health evaluation at this point by someone that's approved by Ms. Turnbull. So it may be that there needs to be an additional, I don't know his credentials either, but those credentials should be provided to the guardian ad litem and to Ms. McLean, so they're aware of what that is.
Your Honor, may I speak? I'm sorry.
Go ahead.
One thing I do remember when it was originally suggested that I was going to need a mental health evaluation, I do recall credentials being mentioned, and I recall it being a master level education or higher, and that is what I seeked out. So, and that was the only person in that particular office that had that level of credentials to be able to accommodate that.
Okay. And it may be very well, you may have done exactly what you needed to do. I just need it verified by Ms. Turnbull. That's all.
Okay.
And am I correct that I heard that Ms. Lovely is doing the domestic violence evaluation?
That's our hope. Mr. Bondurant had reached out to her without a response. And so I have emailed and hopefully connected them so that will happen.
And was there a recommendation on the substance abuse provider?
No, he sought that out on his own.
And do we know can you disclose who that is?
That was done at the Cowlitz Family Health Clinic or Family Health Center.
The outpatient services in
So at this point, I think I've given direction. I think we're getting off
Okay.
into other conversations that can occur offline. Thank you.
Presentation?
What's that?
Presentation date?
So we can set it out 2 weeks. Okay,
23rd at 9 a.m.
9 a.m.
Okay, thank you.
Thank you, Your Honor.
Thank you.
Number 1 on the docket, 13-3-206-4, Bondurant v. Peterson.
Your Honor, I submitted proposed orders on January 10th. I have received no objections from Mr. Bondurant.
Okay, so we have Ms. McLean here. Do we have the other parties here or the other party?
Ms. Turnbull, the GAL, is present.
All right. All right, so I reviewed the file yesterday. I did not see any objections that had been filed. He's not here today. So with that, I am going to sign off on the proposed order.
My office will provide conformed copies to Ms. Turnbull and Mr. Bondurant once it hits Odyssey. Thank you.
Thank you.
Next, I have Chelsea Bondurant and Levi Bondurant. This is cause 23-341-08. I'll ask if Chelsea Bondurant, if you're on the line. All right, Ms. Bondurant, I can't hear you, so if you're here, make sure you're unmuted. Levi Bondurant, I see you. Can you hear me okay?
Yes, I can hear you, Your Honor. Can you hear me?
Yep, I can. And then I see Ms. Turnbull is present as the guardian ad litem.
Good morning, Your Honor.
Good morning. Okay, I have this, and I'll double check once again. Chelsea Bondurant, if you're on the line, please state your name. Chelsea Bondurant.
Chelsea Bondurant.
Okay, thank you, Ms. Bondurant. Welcome. We're here today, from my understanding, I'll turn to Ms. Turnbull for a little greater clarity, is that there is a guardian ad litem appointment order entered on September 12th of last year and made a division of payment. And I think that's why we're here, is to review that payment, but I'm not quite sure. So I'll turn the time to Ms. Turnbull.
Yeah, I was not there on the original appointment date, but there was a division of payment, and that is my understanding that it was going to be reviewed as well.
Okay, thanks. Mr. Bondurant, what's your understanding of the purpose of today's hearing?
Was that to me, Your Honor? I didn't hear which Bondurant you're speaking to.
Yes, sir, Levi Bondurant, pardon me.
So my understanding, it's complicated because I got two different cases, two different cause numbers on different family law matters. One's on this docket and one's on another docket, same guardian ad litem. So my understanding was, I believe we were going to be reviewing kind of the case at this point. I mean, I think right around 5 months, I think, that I've gone without having with having very limited access to my children. The last I remember is that we were waiting on evaluations. There was a lack of an evaluation paperwork having been turned in to Ms. Turnbull, and that evaluation has since been handed over to her for her review. So that's kind of where I'm at right now. I'm hoping that we can gain a little bit of traction here, being that I think my kids are being emotionally kind of torn by my not being able to be around the kids for more than a couple hours a week. And honestly, none of my three want to do supervised visits anymore. And yeah, I think if you ask Mrs. Bondurant, she could also agree to that. So if at the very least we can make some minor alterations to what we presently have to accommodate what's in the best interest of my three children, that would be fantastic.
So let me ask, thank you, I appreciate that input. So related to the guardian ad litem order, generally guardian ad litems, they need to be paid to provide that service. Have you provided that payment to Ms. Turnbull?
I believe I turned in the correct paperwork for the courts to pay for it, Your Honor. I believe that was one of the requests that was made in another case.
So the question is, have you made payment?
No, Your Honor, I didn't believe I was required to make payment. I'm notified Ms. Turnbull that the financial declaration would be sent in and that the courts would assist with that, being that I was unemployed.
So I'm looking at the September 12th, 2023 order appointing guardian ad litem for a child. It appoints Ms. Turnbull. And in paragraph 10, GAL fees, it says the guardian ad litem's hourly fee is $67.50. GAL may not charge more than $1,485 without court review and approval. The GAL fees will be paid as follows. 50% Levi Bondurant, and 50% paid by the public or the county. So it looks like there's the obligation on you to pay the $742.50. So that needs to be paid. If there's a concern on your end that you can't pay that, then you need to bring a motion in this case, asking for relief from that.
3 months later, this is now just being brought to my attention. This was not something that was brought to the attention at an earlier court date, nor the court date prior to that. So I was under the impression that it was going to be waived in this case. So this seems like I'm being kind of like done everything the court's asked me to do and then some, and my kids are suffering because of a lack
You
of
were
payment.
present here on September 7th when that court made that order, and it was filed on September 12th. So you were present, and ostensibly you were aware of what was happening.
120 days later, Your Honor. I'm sorry
You
that
were
I
present during the
misunderstood.
time when the court made that order. So it's not something new to you. You were present during that hearing. So my question to you is, one, when are you going to make that payment? Or two, when are you going to file a motion for relief from that?
As soon as possible, Your Honor, because I've done everything the court's asked in a timely fashion. I was just unaware. I apologize. That is my fault.
Ms. Bondurant, your turn.
Mr. Bondurant is correct in the fact, none of our 3 kids want to do supervised visits. And then doing it at a facility doesn't work with either Mr. Bondurant's work schedule because he works 3 to 11, and then our kids are in sports. And so I've been kind of talking with Miss Turnbull about some options of visits, and how to go about that.
Okay. All right. Thanks. All right. So, Mr. Bondurant, if you're asking for relief from making that payment of that $742.50, you'd need to file a motion to basically revise the order appointing the guardian ad litem to change that payment arrangement. Because right now it has you listed as paying half, and then the county is paying Ms. Bondurant's half.
Yeah, like I said, I was under the impression, I think that there was a little bit of confusion because I think that I was relieved on one case and maybe not another. I'm not entirely sure. But either way, I'm not worried about the payment being made to Ms. Turnbull. I'm more concerned about there being a further delay, being that we're 120 days past that court date and have literally done nothing in terms of my kids having any sort of relief to this situation. So I will hopefully get in touch with Ms. Turnbull as soon as we're done here and see if we can make some sort of payment arrangements to get payment to her as soon as possible.
Okay. All right, that sounds great. So at this point, I don't think we'll take any additional action. The order's in place. And if Mr. Bondurant wants to bring a motion for relief from that payment or wants to make payment arrangements with Ms. Turnbull, he can. And it's important that, yeah, the case does move along so that the parties can have some resolution to this and have greater visitation or what have you. So that's where we're at. I'm not going to set a review hearing. If the parties want to, once things have been sorted out as far as the payment and Ms. Turnbull is moving forward, then she can submit something to the parties as far as a report based on her investigation, or either party could bring a motion related to any type of relief you're asking for. So we'll leave things as is. Ms. Turnbull, any final comments?
No, that's fine, Your Honor. Thank you.
Mr. Bondurant, any final questions or comment?
Nope. Thank you very much, Your Honor. I appreciate it very much. Have a wonderful
I
day.
have a question, Your Honor.
Go ahead, Ms. Bondurant.
So do we still have court then February 28th?
I'm looking at through case minutes. It'll take me a while. I'm not sure. You know what the purpose of it was for?
The GAL findings? Like this one was supposed to be for?
This is what's getting confusing because I feel like this is being misinterpreted by the courts. I apologize, but this was supposed to be some sort of variation of a review hearing today, and it was pushed out 60 days because of a work schedule, because I had requirements to show proof of of working, and it didn't comply to that. And then with the snow, then that it was an additional week. I think Ms. Turnbull would agree that this is an excessive amount of time given the situation. I would imagine I've turned over plenty of information here. My kids are actually suffering from this. Mrs. Bondurant is also reaffirming that, but you're not wanting to hear it.
People don't work for free, Mr. Bondurant.
She's been working.
So
She's been to the residence.
Ms. Bondurant, in response to your question, if there is a hearing date set to review the final guardian ad litem report, we'll strike that because there won't be a final guardian ad litem report finished by that time because there's additional investigation that needs to occur and payment needs to occur.
So where do we go from here then?
As I indicated, once payment arrangements have been finalized, then Ms. Turnbull will finish her investigation. She'll file a report, and then either party can note it up for a motion related to any relief you're asking for. That'll conclude the hearing. Thank you.
All right, number 3 on the docket, 13-3-206-4, Bondurant v. Peterson.
Your Honor, I'm appearing on behalf of the respondent, Tristan Peterson.
Do I have anyone else appearing on this matter? No response.
I also, on this case, did not receive responsive documentation.
Okay. All right, so I reviewed the files and record. Anything you want to add?
No, you should have a proposed order from me that's consistent with the relief requested, and also scheduling a review hearing on April 16th at 9 a.m.
Okay. All right, based on the files and record, I will grant the requested relief, adopting the order. In particular, the petitioner's reply to the respondent's discovery request was emailed to petitioner on October 19, 23.
Actually, that was
the petitioner replied to the respondent's discovery request was emailed to petitioner on October 19, 23. Petitioner shall pay and respondent shall be awarded judgment, the amount of $750 in attorney's fees and costs incurred in bringing the action. Petitioner shall provide and produce all discovery answers and request documentation requested documentation no later than Wednesday, April 3rd, 24 by 12 noon to Noel McLean, and to appear in court on Tuesday, April 16, 24 at 9 a.m. to determine if such was done. If not, then the court will consider striking all of the petitioner's pleadings and enter an order of default against him, or alternatively enter a limiting instruction for testimony at the time of trial.
and we will provide Mr. Bondurant with a conformed copy of the order once it's available on Odyssey.
Okay.
Thank you.
Thank you. All right, number 4 and 5 on the docket, Bondurant v. Peterson matter, 13-3-00206-4.
Yes, Your Honor, Noel McLean appearing on behalf of the respondent, Tristan Peterson.
And Amy Turnbull, the guardian ad litem.
Levi Bondurant is also present, Your Honor.
Okay, please take your hat off. Thank you. All right. So there are 2 matters. First, and we do have Ms. Turnbull present. The first matter is to review hearing for the final guardian ad litem report. And the report was filed, but I didn't put a date. Is it filed? I'm not seeing it.
I mailed it for filing. It may not be
That's right.
in Odyssey yet, but I did email you a copy.
Okay.
And I've received a copy.
Can you hold on just 1 second? I forgot to do something. All right, sir, did you get a copy?
Amy, was that sent by email?
Yes, it was.
Then I would have gotten it. I did not actually. I'm checking my emails now. Yeah, I see something here for it.
Okay. All right. All right, so at this point, I don't have any motions that apply particularly to it. And it's, the report, I know is coming or is already in the process of being filed. I did receive a copy, of the report. Anything further on that matter at this time?
Not on the GAL review.
Okay, Mr. Bondurant, anything?
No, Your Honor.
Okay. All right, so the next issue has to relate with the discovery, and my understanding is no discovery was received, correct?
That's correct.
All right.
Even as of today, I've not received anything.
Okay. Mr. Bondurant, you did not send any of the discovery?
Your Honor, to be completely honest, like I said, I mentioned this, I'm not an attorney. I was not sure if that was something that was needed to be ordered by the court. I just the questions that were asked in that, some of them I was kind of like, does she just get to ask anything and everything, and I have to give that information out there without having been enforced by the courts? And I let her know that over the phone too. So there had been no order by a judge to do so, and I told her if there was, then I would send that information immediately.
Well, the bottom line is that it essentially was ordered in the sense of that I ordered you to provide the discovery, and that if you didn't, then I would be striking your pleadings and finding a default, essentially saying you didn't respond. So that's where
was that
at this point.
Sorry. Was that something that was mentioned in the earlier court date that I may have missed, Your Honor? Because I don't recall that information being relayed over to me. I mean, I could be wrong.
Your Honor, we've filed with the court verification, a certificate of service that was filed on April 12th, that we forwarded a copy of both our proposed order on default and then as it related to the actual order to compel, that has also been forwarded to Mr. Bondurant on March 28th. A conformed copy of that.
No. So on March 26th, there was a hearing. I haven't dug into it to see whether you were or not. I don't think you were, is my recollection, but I still made my order to compel, which required you to respond with the discovery. Now, whether there are possible objections to any of the questions, that I can't tell you. That's giving legal advice. Unless I see objections and the basis for it, and then I rule on it. But at this point, I don't have that. So with that, I don't know what else to do other than to grant the relief, because Ms. McLean's done everything that she's required to do.
Your Honor.
Okay.
Again, I don't understand a lot of the legal terms. I'm getting these emails and I don't even understand them, what I'm getting. And again, from the financial side of it, then I'm being told that I need to, or I'm going to be asked to spend money for an attorney, and if I had one, I would have one for myself to be able to translate these legal documentation. So I mean, it's a lot easier when it's over a court hearing and a judge can actually put it into a language that I can understand. Ms. McLean has made it a point to make it very difficult with me directly, and in terms of explaining what I need to do. I did tell her that I felt uncomfortable on some of the questions, that some of them were redundant. But again, whatever you order, Your Honor, I have to respect, obviously.
So, Ms.
Obviously,
further?
Go ahead. I would just ask that the court grant the relief requested. I have not made this difficult for Mr. Bondurant. I've followed the rules. When he had contacted me I contacted him during our CR 26-9. He told me he wasn't going to comply unless there was a court order, which I provided as far as information in the initial declaration on the motion to compel. I told him I could not give him legal advice because I was not his attorney. He has been advised to contact Legal Aid or Northwest Justice Project for additional assistance if he couldn't afford an attorney. So that's not my obligation to give him legal advice. We've provided him with notice of all of the information and documentation as we moved along. I made supplemental requests for discovery that the court had already determined. And I think it speaks volumes, the fact that he's not even complied with the court order of services relative to correcting his parental deficiencies. And that's outlined in Ms. Turnbull's guardian ad litem report. So my perception is that he's simply throwing his hands up and trying to place the blame elsewhere rather than taking responsibility. So we do believe that it is appropriate to enter the order of default that I've provided to the court. I would note that there does need to be one change made to that order. And that's at paragraph 3B, because I did not anticipate
the claim. I don't seem to, let me see. I don't believe I have your order here. I do have it. It was attached to something else that was marked.
Okay.
Let me get to it here.
So it's entitled Order of Default Ray Motion to Compel.
It's attached as a group together as a bench copy. So let me get to it.
Okay.
So in regard to the files and record, and based on the files and record, the court grants the motion to compel and the request of relief, including, well, the compel is already done. And the request of relief that was made if Mr. Bondurant did not file or provide the appropriate discovery. Mr. Bondurant, Ms. McLean is not your attorney. It's not up to her to explain. She gave you the places that could have been of assistance to you. And so with that, I am going to sign off on the order of default regarding the motion to compel.
So at paragraph 3B, the last sentence, I have Levi Bondurant failed to appear in court on 4/16. If you would strike the words failed to and add ED to appear, so it reads Levi Bondurant appeared in court on 4/16/24. I think that's the only change that needs to be made.
All right, so it should read the petitioner Levi Bondurant has appeared.
I'm sorry, 3B, paragraph 3B. The very last sentence of 3B, as in boy.
Oh, B, okay.
B.
Your Honor, would you explain what the motion to compel or by default what that is, please, if you wouldn't mind?
I also cannot provide you legal advice, but basically what it means is that you're no longer, it's essentially saying that you didn't respond, that you haven't done what you were supposed to do.
Okay.
But to get a full and complete answer to that question, you need to seek out an attorney and talk to somebody.
Thank you, Your Honor.
All right, I've signed the order.
Thank you. We will provide a conformed copy to Mr. Bondurant once it, and to Ms. Turnbull once it hits Odyssey.
Okay.
Thank
That's it for today.
Thank you.
Chelsea Bondurant and Levi Bondurant, 23-3-34108. Is Chelsea Bondurant on the line? Chelsea Bondurant?
Yes, I am, Your Honor.
Okay, welcome to you, ma'am. Is Levi Bondurant on the line?
Yes, Your Honor.
Okay, welcome to you, Mr. Bondurant. I have in my possession several orders that it looks like both parties have signed off on and agreed to. So I'm looking at a findings and conclusions about a marriage. That's one document. The other document is a final divorce decree. The other is a parenting plan, a final order, and also a child support worksheet and a child support order. And so I'm just checking with both parties that's what you want me to sign off on those orders and make those valid court orders. Ms. Bondurant?
Yes, Your Honor, I'd like that.
Okay, Mr. Bondurant?
Yes, we're in complete agreement.
Okay, very good. There was one thing that I adjusted in the in one of the orders, and I don't think it wasn't a big thing. It may have been just kind of the language. And so let me just quickly go through this. I apologize. I should have put a sticky note on there, but I didn't. Let me just see if I can quickly find it. Okay, I think I recognize what it was. I had one quick concern about the tax return, the tax exemptions, but I looked at it again and I don't have any concerns with that. So what you've agreed to, I'm fine with. So I'm going to sign off on each of those orders. And if either party needs a copy of those proposed orders, or pardon me, those final and signed orders, you can come to the clerk's office and get a copy. So I'll
I
sign
do,
off on
I do
those.
have one quick question, Your Honor, if that you wouldn't mind.
Sure.
Did the literature on the house, does that look good in terms of, making sure that it has to be, either sold or paid out to over the course of the next 5 years?
So what I understand, what you all agreed to is that if the house gets refinanced or if it's sold, then there would be some type of payment to Mr. Bondurant, because Ms. Bondurant is going to stay in the home. And if there's a change of that, if the home is sold, and the proceeds, the net proceeds would be divided 50-50 between the parties. Is that accurate? At least that portion
Yes,
of it?
Your Honor.
And then,
Yeah.
Mr. Bondurant?
So,
Okay.
yeah, I think that the only area was, I think that she had a timeline though.
Yeah,
And it was,
5 years.
5 years was what I read.
okay. As long as that's in there, that's okay. That's what we
Yeah.
agreed to.
Yeah, so let me just make sure that that's in here. I remember reading it, but I just want to pinpoint it. So it says respondent, Mr. Bondurant, is not responsible for the debt of the house if foreclosed. If petitioner Ms. Bondurant sells or refinance within 5 years, she must pay respondent Mr. Bondurant his portion of the house.
Okay.
Okay. Any other questions?
No, Your Honor.
Great. All those orders are signed, and that'll conclude the hearing for today. Thank you.
All right. Thank you.
Thanks. Yep, perfect. It's 11:15. We're going to take a brief recess. We'll come back at 11:24, 11:25. We'll take up the Jensen Roads matter, hopefully at that time when we come back. So we'll take a brief 10-minute recess and we'll back on the record. Great, thank you.
That was the last time either of these cases were in court. The current case is over and finalized now, so they shouldn't need to return unless there's some sort of problem or change that needs to happen with their parenting plan. In the older case with his 14-year-old daughter, Mom was given a default judgment in that case, so whatever she asked for was granted. I don't know if Dad has started seeing the child again, but I did see that they have a hearing next month, May 5th, 2025, to modify the restraining order, so it seems like some sort of visitation is being considered. It's been over a year since their last hearing. If I come across anything new in the case, I will update, but I think this case is basically concluded for now. Thank you for watching.